Next matter is 26 TRD 183, State of Ohio versus Richard Lees. I have a ticket from the 7th, charging you with driving under suspension and prohibited use of an electronic device. Did you receive a copy of that?
Yes, Your Honor.
Okay. Maximum penalty for the suspension is 500 hours of community service and a $1,000 fine. Maximum penalty for the texting offense is a $150 fine. Any question about those charges?
No, Your Honor.
Okay. How would you like to plead today?
Guilty, Your Honor.
You understand that a guilty plea is a complete admission of your guilt?
Yes, Your Honor.
I understand you're waiving your right to a trial today.
Yes, Your Honor.
Did you want to say anything today?
I just want to say I wasn't texting. My phone was on the dash with the dash thing.
Okay.
And it lit up, and he was beside me, so he pulled up behind me and said I was on my phone when I wasn't on my phone.
Okay.
I just went down and I couldn't.
All right.
But
okay, well, there's a online distracted driving course you can take to avoid the points for that. You're going to get the points for the suspension anyway, but it also would waive that part of the fine if you wanted that money back.
Okay. Now I'm working on trying to get that suspended license, get my suspension license. Yeah. But I'm trying to figure out where it's suspended from.
Franklin County Municipal Court.
Okay, so I gotta get hold of them.
It's just it's probably just a fine you haven't paid. It looks like.
Okay.
Yeah, in Franklin County. That's it. That's all I see. Do you have a license or do you have an ID?
I have an ID.
Okay.
I had to go down and forfeit my driver's license card because of my work. They said I had a valid ID to get the job.
Okay. Yeah, so you'll have to get a new license, do all the testing and everything. Probably.
Now, would I have to pay for driving school too? Or?
Have you already done that?
No, I have not done that.
Yeah, I don't know. They changed the law about that. You might have to do driving school. I don't know the answer to that. But I've had a couple people tell me that they had to do that.
Okay.
Okay, $150 in court costs. Okay. Next matter is 26 TRD 212, State of Ohio versus Alyssa Gabriel.
Yeah. Okay.
Why did they must appeal? Do you know why this is a must appeal? Do you know why this is a must appeal? It's a mistake. All right, Ms. Gabriel, I have a ticket from January 8, charging you with expired tags. Did you receive a copy of that? Okay.
Yes, sir.
Okay.
Yes, sir.
You can just pay this ticket.
Well, I already renewed my
okay.
tag, and then I called them and I was like, "Do I need to go?" And they were like, "Yeah, if you don't, you're gonna get arrested."
Yeah. So he made a mistake on the ticket. You could have just paid the ticket without showing up, but regardless, you're here. You can take care of it.
So do you want proof that I already renewed or fixed them?
No, that's okay. When did they expire? Was your birthday or
yes,
was it somebody else's? Okay.
My stepdad, he always did it for me.
Okay.
And I moved out on my own and I just forgot that he did it for me.
Okay. Maximum penalty is a $150 fine. Do you have any question about that?
No, sir.
Okay. How would you like to plead?
Guilty.
Okay. You understand that a guilty plea is a complete admission of your guilt?
Yes, sir.
You understand you're waiving your right to a trial today?
Yes, sir.
All right. I'll accept your guilty plea. I'll find you guilty. That'll just be court costs, okay?
Okay.
Thank you. Next matter is 26 TRD 250, State of Ohio versus Thomas Saya. Okay, I have a ticket from the 8th charging you with driving under suspension. Did you receive a copy of that? Yeah, okay. Maximum penalty is 500 hours of community service and a $1,000 fine. Do you have any question about that charge? No. Okay. How would you like to plead today? Guilty? Okay. You understand that a guilty plea is a complete admission of your guilt? You understand you're waiving your right to a trial today? Okay. Did you have proof of insurance for the 8th? You have that with you today? Good. Okay. Yeah. Are you valid now, or you have your license?
The officer.
What's that?
So the officer will be you collected my license.
Yeah.
Here you go.
Okay. Do you know what you need to do to get valid? Okay. Do you have an SR22?
Yeah.
Okay. The BMV says you're not valid. Have you been to the BMV?
Yeah, one day they give me this, they said it's I should run it.
What is that?
So they want it and the EMV give me
Okay. Okay. Oh yeah. Okay. Your CDL is not valid. Is that right? It's just that your CDL is not valid.
Yeah, if I don't have the
Okay.
Medicaid and I'm content on
Okay. Okay. Good.
You're welcome.
Okay. That'll just be court costs today. Okay. All right. Thank you.
Come with me.
Next matter is 26 TRD 155 State of Ohio versus Andre White. Andre Day. Okay.
Take out and get rid of it, okay? Come with me.
All right, Ms. White, I have a ticket from the 7th, charged you with speeding. Did you receive a copy of that? Yeah,
I just don't have it on.
that's okay. Maximum penalty is a $150 fine. Do you have any question about that charge? Okay. How would you like to plea today? Okay. You understand that a guilty plea is a complete admission of your guilt?
Yes,
You understand you're waiving your right to a trial today?
yes,
Okay. I'll accept your guilty plea and find you guilty. Did you have proof of insurance with you?
I'm actually, I'm actually going through a lot right now, to the point I can't even afford insurance.
Okay.
I just lost my, my boyfriend due to him committing suicide down here in North Ohio. I've been homeless, living in my car for a whole 2 years now. I literally just got my car busted, my whole back, literally the same day I got that ticket. And I just replaced my first car with the new car I just got, and I just had it for only 2 months.
Okay.
So right now I'm going through too much, and I can't do a lot.
Okay. So the BMV is going to suspend your license. Okay. For not having insurance.
That's the only way I can get around.
I understand.
Literally living in my car.
That's what they do when you don't have insurance.
1840. He's not going to pay it direct to them. So he's going to have over 2 months to save his money, right?
That sounds good. That's what we're gonna ask for if you had ordered it today. You're gonna ask for 60 days.
Good. So he'll be able to save his money. Make sure you do that, okay? All right, and that's the way we'll handle it. Thank you very much. Thanks for coming. Thanks, Mr. 1840. He's not going to pay it direct to them. So he's going to have over 2 months to save his money, right?
That sounds good. That's what we're gonna ask for if you had ordered it today. You're gonna ask for 60 days.
Good. So he'll be able to save his money. Make sure you do that, okay? All right, and that's the way we'll handle it. Thank you very much. Thanks for coming. Thanks, Mr. Youngs.
You bet. You bet.
Reginald Steve Wilson Jr. Are you here on Ebony?
I am, Judge.
Do you have the file?
I think Sadie's handing it to you right now.
We have the lawyer on Zoom.
We do have them here, Judge.
Okay, you can bring them in and tell them to mute. I'm going to take this arraignment real quick. Reginald Steve Wilson Jr., 25B149900A.
Good morning, Your Honor.
And B. Good morning, Mr. Sparrow. How are you?
Really well, thank you. For the record, James Sparrow, E57197 on behalf of Mr. Wilson.
Sir, your name?
Reginald Steve Wilson Jr.
All right, so today's the date scheduled for arraignment and pretrial. For purposes of arraignment,
Your Honor, my client will stand with you with a formal reading.
not guilty, please enter. Does he have any priors?
He does, Your Honor, a couple of years ago in this court, and I was going to ask if I could possibly get a sobriety court checklist packet.
Absolutely. Be glad to have him.
I can also let you know he did contact the guidance center yesterday. He's got a schedule today to either set up or do a screen.
It was a 199 and he just had one. What was the other one?
I do not recall.
Look, I gotta have him on a sober link, okay? So I'm gonna give you a $2,500 personal bond, sir. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to attend AANA at least 3 times a week, okay? And your defendant to be on sober link device by the end of the day. So I'm just telling you, according to how I've handled this, if you have 2 within 4 years and you have somewhere around a 2.0, I mean, you got a 199. Unless you get into sobriety court, you're likely to do a few days, okay? I think it would be best for you. Now, I'm not prejudging everything here. I don't even want you to talk about the case. You're still not convicted. You might never be convicted. You're presumed innocent, but I do want you to understand that, okay?
Yes.
So you have to be on a sober link by the end of the day. No alcohol, marijuana, or illegal drugs. AANA 3 times a week. We're handing you the form. You have to go in person. Every time you come to court, you have to bring the form with you. What do you have for me, Heather? Did you present a discovery order by chance? Do I have it here?
I know I did not.
Okay, that's all right. I mean, whatever you guys want.
That's you, you know.
Good enough. Pretrial will be
How far out do you want to go for this one? If we're going to
2
do
weeks.
sobriety court? You just want to do 2 weeks still? Okay, we can do January 28th.
I'm out of the state that week.
okay. The only thing is with sobriety court, I want it, if we're gonna do what I want, all statistics tell us the sooner we get them in, the better. But I'll, do you have another date a week later? We don't want to stop Mr. Sparrow from going on vacation.
I appreciate that.
I hope you're going somewhere warm.
Phoenix, very.
Very. Do I have something the following week, Heather, with Brownstown?
Brownstown's in the building for Judge Hessen on the 4th.
Okay, so I don't have Brownstown till the 11th?
Correct, Judge.
We'll do the 11th at 8:30. Is that good with you?
Very good. Your Honor. Thank
Okay.
you so much.
You go down the hall, get your notice, sir, and then I want you to meet with probation. I'm entering a plea of denial and a refused PVT, okay?
Thank you. Your Honor.
Thank you all.
Did you have a packet that I could get today? or-
Yeah, you can go over to probation, and I'd suggest you talk to the sobriety court probation officer,
Very good.
okay?
Thank you.
Thank you. Ebonique Allen Hunter Smith, 22WA29943 A and B. All right, good morning, Mr. Dubin. Your name?
Good morning, Your Honor, to you and your staff, Attorney Maxwell Dubin, P number 86012, on behalf of Ms. Hunter, who appears via Zoom.
Ms. Hunter Smith, your name?
I'm Ebony Connor Smith.
Ms. Wilds?
Elizabeth West, Your Honor.
So I felt compelled to bring you in here today, Mr. Dubin. My apologies.
No, I'm actually coming to see you in person right after the Zoom, so I'll be there in person.
Okay, so I want to clarify something. This is not personal, Ms. Hunter Smith. I told you that if you didn't get into sobriety court, based on your record, based on everything that's happened, that you were going to do some time.
Okay.
But now I'm told that you're asking the probation director or saying, listen, so I'm definitely not doing time. The judge told me I wasn't doing time if I get into sobriety court. I want to be clear with something. I am not guaranteeing anything. I want to be clear with it. Okay?
Okay.
So if that changes your mind, fine, we can set this for sentencing. I didn't say that I was sending you to jail if you get into sobriety court. I did say, let me clarify. I'm not making any promises. The only promise I'm making is if you don't get in the program, you're going to jail. I'm not trying to scare you. I'm very reasonable with people that show me that a willingness to get into sobriety court for the right reasons. Do you understand what I'm saying? It's not, that doesn't include for a restricted license. That doesn't include people that are getting in the program just because they don't want to go to jail. Because you know what? I've been doing this a long time, this job in sobriety court. And most of the people that get into it for the wrong reason, that is restricted license or not to go to jail, they don't make it. So I just want to clarify, I am not making promises of any kind here. The only promise I am making is that if you don't get into sobriety court, you will do time. Am I reasonable? Call around, ask around. Mr. Dubin, you can call around and ask around with the sobriety court what I do. I feel really good about what I do because I want to help her, but I don't want her tormenting and I'm not saying she was tormented.
I understand. I think my client understands his figure of speech, Your Honor.
Okay. I don't want her bothering getting the probation director here to say she's not the judge. She's got nothing to do with this. I'm sure she goes out of here and disagrees with some of the things I do. It's okay. Everybody has the right to disagree with me. It's all right. I'm okay. I got a thick skin. But I just want Ms. Hunter Smith to understand there are no guarantees. And if you're doing it just for me, that is, I'm going to do sobriety court to appease the judge and I'm going to hate it for 2 years. Honestly and truly, it's not worth it because you won't come out better. I told you you're going to like me at the end if you, and I didn't say this. You will only like me at the end if you're doing this for the right reasons. If you're not, don't bother. It's a long stretch. I'm not going to lie to you. It's a long stretch. You're looking at 2 years of probation and strenuous requirements. But the purpose here isn't to force or intimidate somebody into doing sobriety court. It is to help people alleviate what I perceive to be their problems, period. So I just want to put that on the record. There's nothing else to say. So far, she's doing good?
She is, Judge. I just met with her yesterday. She's scheduled to meet with Agera January 15th. She provided her 12-step meetings. I think we had a great conversation. And I think she is starting to understand a little bit more about the program and the process.
I'm gonna be fair with you, ma'am. I'm not an ogre up here, ma'am. I'd want to go in front of me if I got in trouble. That's all.
And Your Honor, if I might add, my client, Ms. Smith, she's completely capable. She really does. She's got a great head on her shoulders. I think she just needs the correct guidance, and that's it. And understand.
She's a smart lady. I can tell by talking to her. I really can. I want to get her doing better than she even can imagine at this point. And I don't know what she does for a living. I don't remember, but that's it. That's all I have to say. You guys have a great day, unless either one of you have a question, Mr. Dubin.
No, I will see you. I'm going to head to the court right now. I have an arraignment with you at 10, so I'll see you in a little bit.
Have a good day. Good luck, ma'am. Thank you. Priority Waste, thank you. Priority Waste LLC, 25B150019 A and B.
Ready, Your Honor. Just give me 1 second, sorry.
Mr. Dillon.
Yes, Your Honor.
Start your video and I want to talk to you, okay?
Yeah.
Your name?
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste.
So why, can I ask you a question? Is it
Yes.
just, you're not in a moving vehicle, right?
No, I'm parked.
Okay. Listen. Are we adjourning this for a purpose?
Yes,
Other,
Your Honor.
what is the purpose, other than to give
Yeah.
them more time? If you need more time to pay, I'll be glad to do that. I mean, I really will.
It's not more time to pay, actually. It's my schedule and the crunch of business. These last 2 weeks have been absolutely insane.
Fair enough. You don't need to,
we've
you don't
done-
need to,
Yeah.
you don't need to say anymore.
Yeah, it's on
Give me a
me.
new, that's all right. You got, give me a new date if you would, Heather.
Okay, Judge, we can do January 28th
At
at
what
9
time?
o'clock.
At 9 o'clock. You good then?
Is
Yes.
this for all of the priority waste that we have for you today, Mr. Dillon? Because I had
Yeah.
one.
No, I got another one too here. I got a
Okay.
couple more
Not-
here. I didn't call them all. I'll
Oh,
call
okay,
them all
Judge, that's what I
now, but
wanted to
we'll
make sure.
adjourn this one to January the 28th. And that will be at 9 o'clock. I also have 25B149760 A and B, 25B150100 A and B. And that's it. Your appearance again?
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste.
For purposes of arraignment on these, does the company stand mute, waive reading?
Yes, we do.
Not guilty, pleas entered. I'll adjourn all of these. That's what you want. I'll take them. Well, this one's November 19th. Why are we adjourning this one again?
Which ticket number?
This is 25B149760. Look, I'll give you one more adjournment, but
Thank you. That's it. I got
this
it.
is like the fourth one. January 28th at 9 on this one too, okay?
Yeah, 760, we did ask and receive a discovery, and it's in process. It's just part of this crazy schedule. These last few weeks have been a
Good
little
enough.
much.
We'll let it go.
See you on the
go-
28th. I appreciate your time.
Have a good day. Thanks.
Thank you, Judge.
Bye now.
Bye.
Carrie Ruth Moran. Carrie Ruth Moran, 15W806545.
She's
Yeah.
on Zoom, Judge. They're coming in.
16W810025. Your appearance, Mr. Carmen?
Morning, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
Where's Ms. Moran today? Your name, ma'am?
Gary Moran.
Where was she?
Your Honor, my client's had a number of serious health issues, basically since her case began in 2016. Yesterday, if the court would like proof, she did fax in about 18 pages worth of that medical history. I've gone through it, and basically, this past November, she had a recent stay, an extended stay in a nursing home for a sepsis issue and also had a tracheotomy. She is currently bedridden and not able to work.
At some point, I gotta end this case. You know what I mean? This case has been going on since, it's a 2016 case,
Yes, sir.
and the other one's a 2015 case. Why wasn't she here on the 7th? Why weren't you here, ma'am?
I apologize for that, Judge. I had come down with some kind of bug and I lost my voice and I was not able to communicate. So I'm sorry about that.
You know how many times I've had this scheduled, ma'am?
Yes.
Listen, Mr. Carmen, I gotta set this for trial. I don't care if you want a jury or a bench. I'm setting this for trial. I can't keep going on like this. So you want to set a jury or you want to set a bench trial?
Your Honor, I'd have to
Well,
talk
you
to my
aren't the
client a little bit
lawyer.
more about
Okay.
that. I haven't even gotten to the underlying facts of the case. I'm just the arraignment attorney,
I
but
got it. Okay, listen.
I can spend some more time with it, gladly.
No. Wait. The, Heather, when is Woodhaven in front of me this week by chance?
Not this week, Judge. No, we don't have Woodhaven again until the 4th.
Yeah, and I don't even know if they're gonna be able to. That's
Wait.
they have to go. Ma'am, if you miss again, I don't know anything about your voice, but you should have at least called the court and told us. Okay?
Yes.
You could have zoomed on and chatted. You didn't do that. And now you're showing up here a week later. Final pretrial will be February 4th at 8:30. Notify the lawyers. I'm also setting it for a jury trial. We're going to set it within 2 weeks after that, so I can go to February the 20th. That's it, at 8:30. So you're gonna have to notify Mr. Urick, if you will. This is a Woodhaven case. So you can notify him and notify Mr. Crawford. That's gonna be the next 2 dates. So they're either gonna have to resolve it. Ma'am, if you miss again, look, I don't care what they do with this. Under the circumstances, I could care less if they choose to dismiss, do whatever they're gonna do, but I gotta move the case. Okay? I mean, I can't have cases hanging around here that are 10 years old. So that's all I'll say about it. That's what we're gonna do. Thank you very much.
Your Honor, do you want me to follow the case?
No. Mr. Crawford's been on this, I believe. His name's on the file, so I'm sure he's on the Woodhaven docket. He can handle it. Thank
Okay,
you.
I was gonna say, I'd
Thank
be
you.
happy to if that's what the court wants.
No, that's fine. Thank you very much.
You're welcome.
Mathis or Mathis?
Yeah.
Manager Mathis, 25B150098. Do I have that Boyd file? Heather, I only have one court to school on the 27th, don't I?
Yes, that's all we have right now, Judge.
Gotta find somebody today. Your name, ma'am? So you have the right to an attorney. You're charged with driving on a suspended.
Yes.
If you would like an attorney, I'm going to provide you with one right now at public expense. Would you like an attorney?
No.
So you waive your right to a lawyer?
Right.
I'm going to go ahead and arraign you then, and then I'll send you to the prosecutor and you can speak to the prosecutor, okay? It is alleged that on December 11 of 25 that you were operating a motor vehicle with a suspended license in Brownstown Township on Sibley near Dix at 9:12 in the morning. That is a misdemeanor. It is punishable by up to $500 in fines, 93 days jail costs, or all those 2 points. Do you understand that?
Okay.
And did you sign, read, and understand an advice of rights form today? If you plead guilty at any time, you'll be giving up all those rights and we will not have a trial. You understand that? You still wish to waive your right to a lawyer?
Yep.
Men are not guilty plea. And this indicates you stand mute. I'm gonna give you a $500 personal bond, and here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. You can go out in the hallway. My court officer is gonna bring the file to the prosecutor, and then as soon as she's able to see you, she'll call you in, okay? All right, good luck. Do I have Mr. Boyd's file? Are you here for your hearing today, Mr. Boyd?
Yes, sir.
Okay,
Cleveland, do you have Mr. Boyd's file?
I do, Judge. Do you want to run it in?
Please, and bring in the ordinance officer. If he,
I'll be in it.
okay. How you doing? Did you have surgery?
Not yet.
Okay,
Sweet.
sorry. Okay, I'm gonna ask you to stay here. People against Robert Thomas Boyd, 25BA2557. How you doing, Mr. Boyd? Come up to the podium. Ms. Foley Carter, your name?
Caitlin Foley Carter, Nebraska Township.
Mr. Boyd.
Robert Thomas Boyd.
So you're here for a review hearing. And you have the right to an attorney. If you would like an attorney, I'm gonna give you one now.
No, thank you.
You waive your right to a lawyer?
Yes, sir.
Please tell me. Please tell me. Please tell me that there's been substantial progress on the property. I'm talking to the prosecutor.
I would define it substantial, Your Honor. I did have a department, somebody took photos from the street on Thursday. It shows the boat, the off of the vehicle, the trailers. He got a large delivery of wood that is now in front of the property. There's junk along the side. I do have those photos if you want to take a look at it. It does, I do see that the trailer in the back of the property is full. Mr. Boyd did say that it's full. It just needs to be cycled out and he needs to keep working on it. He also has not obtained a demolition permit yet for that dangerous building back in the back.
I don't know what to do with you.
I don't know how long it's good for, so I'm waiting and, I can't get the trailer out because the guy went up deer hunting and then he's up north with his boss. Working on.
Whose trailer is that?
Cabin,
Whose trailer is
but he's coming
that?
back,
Whose trailer is that?
The dumpster.
yeah.
Wait a minute. So it's being used as a dumpster, the trailer is?
The trailer is a dumpster.
Okay.
That dumpster, you can see in some of the photos.
Yes.
That is full. There's still all the trailers being used as storage essentially though on the property.
What are you doing with the boat?
Trying to sell it. Got his for sale sign on, it, got it up by the road.
How long's that been, how long you had that up for sale?
Well, it's the middle of winter and
No, I didn't ask you that. I just want to know, can I have
Oh.
another page, second page to a register of actions?
since,
I think it's been about September or October, you know.
All right, talk to me, not to her. You
No,
I'm
it's
just-
in November when we put it on.
I mean, it does look a little better. I'll give you that. But you still gotta get the boat out and you gotta get the
Yeah,
garage torn down.
I've had the flu since Christmas.
What's in the trailer?
I believe that Mr. Boyd has taken property out of the garage and that's what's in the dumpster.
Well, no, but there's a trailer. Is this not a trailer? This black, it looks like a black trailer to me.
Yeah, there's 3 trailers on the property. They're just full of, excuse my language, junk. So those need to go. You can't use storage like that on the property.
When are you gonna get rid of the junk in the trailer?
A lot of it isn't junk.
What's in the trailer?
Tools. I gotta put my, rototiller in there. My lawnmower in there.
Tools,
Yeah.
lawnmower?
Yeah.
What else? Is it filled up?
No,
What else do you have in the trailer?
yeah, I got some kitchen cabinets that I gotta put up
You're gonna put them where?
Huh?
Where are you gonna put them?
in the kitchen.
How long have you had the cabinets in the trailer?
November, December,
Where'd you get the cabinets?
my daughter. She,
What?
remodeled her kitchen. And, they're all handmade cabinets. They were too dark. She wants white.
Who's gonna take the dumpster out of there and take it to the dump?
The man who owns it. I rented it. $400 a shot.
Is it filled up yet?
Yeah, it's good.
When's he gonna come get that?
I'm gonna call him today, see if he's back in town.
What about the other inoperable vehicles?
The inoperable vehicle. Got a broken shock, I gotta put it into the.
These are the same vehicles been sitting out there.
They are, Your Honor. See with the trailers, those have all been there since we did this.
I don't know what you're gonna make me do, Mr. Boyd. I really, Mr. Boyd, come on.
I gotta work on the garage, getting it in. Everything else is secondary.
Well, that's your opinion. That's not my opinion.
You do one thing like that at a time.
Mr. Boyd. Mr. Boyd. I'm gonna let the prosecutor remind you how long they've been dealing with this, with your property.
Your Honor, I believe these citations date back to 2001.
So it's only been 25 years,
I didn't know about it.
Mr. Boyd. I don't know why you're not good. I don't know why you're just insisting that I send you to jail. I don't understand it.
I can't do anything, you know.
Mr. Boyd, you're not doing anything out of jail either.
Can't do anything.
Mr. Boyd, this has been 25 years. 25 years, sir. I was young. I'd like to go back 25 years. This is my early 40s, 25 years ago.
Nobody come and talk to me. Except for, the guy that retired.
Yeah, what year did he come and talk to you?
Just before Rob took over.
What year was that?
Last year, 25.
So you're saying you didn't know anything about this until 24? The township hasn't been bothering you to get this junkyard picked up, sir?
Well, he just coming.
Sir, I'm asking you when your first notice was from the township that you had a blight condition, they wanted things out of there.
Nobody called it a blight condition.
Sir, when did you hear from this township in reference to the condition of your property?
Probably 24.
So you guys are off by 23 years. She thinks it was 01, you think it was 24. That's one big difference. Now, I hear a lot of opposite stories here. Some people call it one, some people call it a million. I hear different stories, but that's quite a disparity. That's 23 years, not 23 days, not 23 weeks.
That's when I got the letter in the mail. 24.
Would you look on the computer, please, for me? Can you pull up Mr. Boyd's name, please? I like you. I do,
I like you.
but I have a job.
So do I. I gotta get that.
And you're not following orders of the court.
Nothing I could do with being sick.
Mr. Boyd, you've given me every excuse under the sun.
Oh, it's a bad flu.
Well, let me see here. I see Robert Thomas Boyd. Allow inoperable vehicles, 2002. Improper storage, 2003. There's other ones that were set aside under a statute, building code violation 24. So they were dating back to 02. I don't know why they let it go from 03 to 24, if that's what they did, but you've had since April of 25 to get rid of this stuff. And I don't know what to do with you other than just lock you up. Like,
I think if it was,
Mr. Boyd,
2002.
Mr. Boyd, I've had every excuse under the sun from you. I don't know how many times you've been in front of me on this case. I have had every excuse under the sun. You're sick, your boys won't help, they're too busy, you don't have the money, you gotta go to work, it's too warm, it's too cold, it's too this, it's too that. And here I am trying not to send you to jail and knowing when I don't send you to jail that I'm not handling my office appropriately. You know that? That's what I'm doing. I'm not handling, I'm just not following what I should do and what I do. So basically, somehow, some way, I've treated you better than I treat anybody else.
I appreciate it.
Well, no, but I don't want to treat you better. I feel sorry for you. I'm trying to help you. I'm trying to reason with you, and you're not taking any reason. You're just not going to listen to judges. You just don't. I don't know if you think I'm kidding up here.
I'm working on it. I've got 2 trailers full of junk out of there already. 2 dump trailers. They're big.
You got to get the garage done. You got to get the trailers out of there, the dumpsters. You got to get the junk out of the trailer. You got to make sure that your vehicles are operable, not inoperable.
Yeah.
Are they properly plated? No, they're not properly plated either, are they?
Yes, they are. And they're insured.
Why did the township wait so long? If they were dealing with this in 02 and 3, what took them 21 years to start?
It wasn't
Hang
like that.
Hang on, let me talk to her. I was talking to her. I wasn't talking to you. Why did they wait so long?
Jerry, do you know that he has issued municipal civil infractions that are handled through the township along with multiple notices?
Are you gonna deny that too?
What?
She just told me that multiple municipal civil infractions, which would not have been filed here, were issued to you many times between 03 and 24. Is that true or is that false?
I had.
True or false? Just give me a straight answer, please. I don't want to have to be a dentist today. I just don't. Is that true or false?
Well, it's not that simple.
Did they send you certain municipal civil infractions or not? It is simple. What's hard about that? It's either yes or it's no.
In 2003, I had 2 cars in my yard.
Mr. Boyd, I'm just asking you a simple question. Between 2003 and 2024, did this township send you municipal civil infraction violations or did they not? In other words, is she lying to me? Is she lying to me?
I wouldn't think so.
Okay, so they did send you notices, right?
But I have.
Right? Right or not? Please tell me if I'm right. I'm gonna get agitated if you keep playing with me. Did they send them to you or not?
I don't know.
You don't know?
My ex-wife picked up the mail.
Oh my gosh. You know what I want to do to that? That's what I want to do to that. That's ridiculous.
She didn't like me too much.
Boyd, you got 2 months to get everything taken care of. I'm gonna give you one last chance. This is not a threat. This is a promise. I'm gonna adjourn the review hearing. You've got to get, you got to do this. This is not a request. This is not a suggestion. I'm not asking you anymore. I'm telling you, this is what you're gonna do. Do we understand one another?
Yes, ma'am.
The last thing I want to do is put you in jail. But I'm going to do it if you don't have the property cleaned up like I told you multiple times. Give me a date in the end of March, Heather.
We could do March 25th, Judge.
March 25th at 8:30 in the morning. You want to take your, did you have something to say?
Just briefly, I did want to remind Mr. Boyd, I know we talked about it a little bit, is that there's a Good Samaritan with a team of people that want to volunteer to help him clean his property. It's my understanding that he says that he doesn't need her yet, that he had one person before, but I think that this is a much larger problem.
They'll help you.
Yes, sir.
If you,
I have to have somewhere to put it. The trailer in my yard, the dump trailer is full. That guy's been away for 6 weeks.
well, tell them to come and get it.
I did.
Listen to me.
He's telling me.
Take the help that the township's offering you. There's going to be no excuses next time. You understand? You do what you got to do, but I'm telling you right now, you've been in front of me on a multitude of occasions on this case, and I'm telling you, if you don't have that property cleaned up to my satisfaction in a compliance with the orders that I issued previously, I'm giving you the other remaining days, whatever they are. Do you understand me?
Yes, sir.
Take your photographs back, please. You can keep these and you can mark down what day they were taken so you can bring them next time and have updated photos. Thank you very much. Go down the hall, get your notice, sir. Good luck. I'm telling you, I'm not going to do this again. Marcus Liddell Allen Jr., 25B149, 652 A and B.
Good morning, Judge. Imagine getting a print back from Mr. Allen.
Mr. Allen, your name?
Marcus, but
Counsel, I've got a favor to ask you, if you can do it. You live on Perry Lane, sir?
no,
Where? What city?
no.
I got a court to school program. I need another participant. January 27th at Brownstown Middle School. Mr. Allen, you don't have to do that. If you choose to do that, I'm not gonna lie to you, it's a little more embarrassing, but these are just middle school kids, 6th, 7th, 8th grade. I will give you credit toward any jail, court work, or community service. And for appearing there. And I'm also gonna give you credit for today, since you've been sitting around here for 50 minutes. Can you do it January 27th? You'd have to be there at 7:45 in the morning.
I'm not here on the 27th, Judge. I've got jury selection at 16th District Court.
In Livonia. What time's that start?
I believe that's scheduled for, I want to say 9 o'clock, but I have to check my schedule.
You just went over this today with him, right? Mr. Shemke was his lawyer before. Is that true or false?
Correct. Well, I was told it was Mr. Crawford. Is that right, John?
This was Allen?
Yes.
I'm sorry. Okay, I misspoke.
Oh, it was Mr. Shemke?
I still can give you a lawyer that can go over this just as he did today. All right. You good with this? You don't let me down now. I need you there, okay? We're gonna see. It starts at 8:15, right, Heather?
Yes, Judge.
So I need you there, and you know where Brownstown Middle School is? All right, so you don't need a map or anything, right?
Nope.
All right, I'm just asking, okay, so you're gonna be there January the 27th, and I need you there by 7:45, okay?
Yes.
Heather, we need another lawyer for him, okay?
Okay, Judge.
So don't let me down. I can't have you late. They won't, they're gonna walk in there at 8:15. I need everybody ready to go, okay? I really appreciate you doing
I'll
that.
give you the notice.
Hang on, I need to make a note here. Heather, they're gonna bring the file to you. You just write on the register that I said I'd give them credit for today and report to school today. I don't usually give them credit for today for sure, but I'll
Yes,
do that
Judge.
for you, okay? Good luck. Thanks for doing that.
Mr. Allen, just go down to the clerk's window and get your notice.
Do you have Smallwood?
I do.
John Gregory Smallwood. Has this been yours? This is 25B149428.
Judge, on the paperwork, it's in pro per, so I don't know that he had an attorney.
Oh, no, you didn't. Your name, sir?
John Smallwood.
So you didn't talk to him or anything?
Today I did.
Well, he waived his right to a lawyer, I believe, right?
Today?
Well, I'm gonna ask him again,
Okay.
but I don't know why they would have given you that. If you said- That's okay. So, sir, you have the right to a lawyer. And I would be happy to provide you with one at public expense.
Okay.
You waive your right to a lawyer?
I do.
Are you willing to do this? Court to school, like I just explained?
Stay close to school.
Yeah, I don't know if you were listening or not. I just covered this with that last gentleman. I'm doing a sentencing at Brownstown Middle School on 3 or 4 different cases on January 22nd. I'm not gonna lie, it's gonna be more embarrassing than here. What is it, 4 people in here or something? But it's just 6th, 7th, and 8th grade students. I'd appreciate it. You don't have to do it. If you tell me, Judge, I just don't feel comfortable, I'm gonna sentence you now. If you're willing to do it, I'm gonna give you credit not only for today, but for that day, for any jail, court work, or community service. Do you understand that?
I do.
Are you willing to do it?
I am. I have children of that age and experience with that kind of.
They're not gonna be, they don't go to Brownstown Middle School, right?
No, they're in Riverview.
All right, so I appreciate that. I need you there though by 7:45, okay?
Sure.
So it's gonna be 1:27. We'll give you the notice down the hall by 7:45, all right? I really appreciate you doing this.
No problem.
And and Heather, make a note on his file as well, giving him credit for today on the register and for the court to school day, okay?
Okay,
All
Judge.
right. You're all set. Do you know where Brownstown Middle School is?
I'll find it.
We'll give you a map. Can you give him a map, please, Heather?
Yes, Judge.
Thanks a lot. Go down the hall, get your notice. I really appreciate you doing this. Thank you. If anything, I'm easier in those days. All right, you're all set. Good luck.
Judge, you did tell Mr. Allen 8:15.
Did I say 8:15? I missed.
Mr. Allen, yes. In case you want to let me.
No, I told him 7:45.
No, you told him 8:15.
You did tell, I have 7:45 on the notice. It starts at 8:15.
Yeah, that's okay.
No problem. Thank you.
Better safe than sorry. Thank you. Wendy K. Augustinus, file 25B149340. Morning, ma'am. You can come right through there. Just come right through there. You're good. Go up to the podium, tell me your name.
Wendy K. Augustinus.
Why weren't you here on December 17th?
Sick. I'm still on antibiotics. I feel like
Did you call the court and tell them you were sick
I did.
on December 17th?
She said that it was
You have the right to a lawyer. You're charged with parental responsibility. It said your son threw rocks at a vehicle causing damage to a motor vehicle. Hang on a second. I'm gonna give you a lawyer if you want. You want a lawyer? Are you sure? I'd get a lawyer to free. I don't like the nature of these charges to begin with. Huh? We'll give you a lawyer. Go out in the hallway. My court officer will bring it out. And the lawyer will negotiate with the prosecutor, all right? Now, either way, you're coming back in front of me, all right? Good luck. All right, well, we're gonna take a recess. I don't have anything else ready. As soon as something is ready, I will come back out. Okay, everybody can stay seated. Thank you.
Judge Simpson presiding.
You may be seated. You wandering or? Okay. Check it. Court does call the case of the people versus Brianna Jones.
Public Defender Natalie Pate with and on behalf of Ms. Jones, who appears via Zoom from the MDOC. Ma'am, can you please get someone to unmute you and state your name for the record? Is it on mute?
Yep, state your name.
Okay, Brianna, Brianna Jones.
Thank you. Go ahead, Ms. Gray.
Thank you, Your Honor. Today's the date and time set for sentencing. Ms. Jones and I have had the opportunity to review the pre-sentence report as well as the recommendation, and we would respectfully request the court adopt probation's recommendation.
All right, Ms. Jones, is there anything you'd like to say before I do impose sentence?
No, I just want to apologize for my actions.
It's a sentence of the court, $125 statutory fees, 93 days in jail, credit 93 served. All right. Thank you, Ms. Jones. Good luck to you.
Thank you. Have a good day.
You too.
Thank you, Ms. Jones. Thank you, Your Honor.
Court
Thank
calls
you.
the case, people versus Brandon Nash.
Good morning, Your Honor. Sarah Sallin from the Michigan Civil Criminal Litigation Clinic on behalf of Brandon Nash, who is present via Zoom. Brandon, can you state your name, please?
Brandon Nash.
Thank you. And good morning, so.
Morning.
morning,
And
Judge.
Sherilyn
Good
Foster
morning.
Tucker on case 1195.
Okay. Who wants to go first?
You can go.
Sure. Excuse me, Judge. So today is also the date and time for sentencing. I've had the opportunity to review the pre-sentence report with my client regarding our case. We respectfully ask the court to adopt the probation's recommendation. Just to add, since being placed on bond, Mr. Nash has been fully compliant with his conditions. He's actively studying for a chauffeur license. He's recently been hired through his ministry as a cook preparing hot meals for individuals experiencing homelessness. So with that, we'd ask you to adopt the recommendation.
And on our case, we would also ask that the court adopts the recommendation.
All right. Mr. Nash, is there anything you want to tell the court before I do impose sentence?
I just want to apologize for being in front of you guys, and I take full responsibility. And I'm just glad we're at the end of this, and I appreciate everything you've done for me, Mr. Simpson.
Okay, well, thank you, sir.
You're welcome.
All right, on the case ending in 1109, sentence of the court, 12 months probation, $480 fines and court costs. I'll waive the probation fees on this case as I'll impose them on the other case. $732.95 restitution to Dick's Sporting Goods jointly and severally with the co-defendant Devontae Johnson, and that is payable through the court. When can you pay all of that? You're also going to have additional fees and restitution.
I can make payments. I tried to make a pay
Okay, I'll impose court costs, 18 days jail, 3 days credit. Any question about that sentence? Thank you.
Yeah.
Going to be able to do the hearing with your connection if that.
Case yesterday, and I know that we had a recommendation.
We're not going to be able to do the hearing with your connection if that's something. It's making it seem like you're underwater. I just got a message from my assistant, and she said that Washburn is having internet issues. So
Okay,
whatever,
should I try and log off and log back in?
that would be great if you could do that.
All right, I'll try.
Waiver of jury trial. At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today? Yes. You understand you're giving up the right to question any witnesses the state would have against you? Yes, sir. And you understand you're giving up the right that the state proved beyond a reasonable doubt you did in fact commit these offenses? Yes. Okay. Ms. Dan, you want to have the prosecutor recount the facts today?
No, Your Honor, we stipulate to the facts sufficient for guilty findings.
Based on that, I'll accept Mr. Diamond's guilty plea as being voluntarily and intelligently made, knowing what his rights are. I find him guilty of assault, menacing, trespass, possession of drug paraphernalia, theft, and disorderly conduct. As Mr. King and Marcy's law been complied with, who has the assault charge?
I've got the 0888.
Okay.
It has been complied with. She never really opted in.
Okay.
We have had contact with her to get her input, which was needs help and treatment. She was advised as best we could regarding today's hearing, and she is not here to the best of my knowledge.
Okay. All right. Restitution on the theft charge.
Yes, Your Honor, there is.
We will go on the record in the matter 13 CM 280, State of Wisconsin versus Benita Penaloza. We're set here today in this matter for a sentencing hearing after revocation. All parties in some way or form are appearing by video conferencing, except that James McLaughlin and his client, who is in custody, are appearing in the Washburn County Court. District Attorney Aaron Marco is appearing by video conferencing, as is this court, who is appearing from the Burnett County Courthouse. Again, set for a hearing after revocation. The court has reviewed the revocation packet and all matters as it relates to the previous sentencing in this case. Mr. McLaughlin, is your client okay with everybody appearing by video conferencing and not in the same room?
Yes, Your Honor. Her name now is legally Spencer, S-P-E-N-S-E-R, correct, Ms. Spencer?
C-E-R.
Oh, C-E-R, I apologize, S-P-N-C-E-R. And you are agreeable to this proceeding being handled in the technological manner recited by the court, correct?
Yes.
Thank you.
All right, thank you. And I apologize, I don't have that information that it is Spencer, or if I did in the revocation packet, I'm sorry, I would have kind of overlooked that because I have your name as legally Penaloza, okay?
That's
So I
okay.
apologize. Oh, I did see it. I guess I see it in parentheses. Okay, so anyone notice anything, any material information that needs to be corrected on the record, Mr. Marco
Not from the state, no.
and Mr. McLaughlin?
Your Honor, I have reviewed the sentencing after revocation packet verbatim with Ms. Spencer, and we see no additions or corrections. Correct, ma'am?
Exactly.
Nothing in dispute, Your Honor.
Thank you. And Mr. Marco, to the best of the state's ability, are we in victims' rights compliance?
I believe that we are.
All right. Okay. Thank you. Argument, Mr. Marco?
I believe that we have a joint recommendation for 4 months in the county jail. The Department of Corrections recommends 3 to 5 months, and looking at her criminal history before this, she only had 1 prior conviction for retail theft. My understanding is that there was a $62 check that was passed without sufficient funds. Following that, she basically absconded for probation from over a decade. She returned, was caught, and Attorney McLaughlin sent me an email. I believe she has approximately 72 days of credit. I think that is sufficient in this instance, and I would ask that all financial obligations that remain be reduced to civil judgment.
All right. Thank you. Mr. McLaughlin?
Everything is accurate about what Mr. Marco said, Your Honor, except she has 97 days credit from October 10, 2025 to today's date of January 16, 2026 is 97 days, Mr. Marco. Would we agree on that? Yes, we can agree on that. I apologize for misspeaking. I was working off memory. I didn't have your email in front of me. All right. May I just briefly address the court, Your Honor?
You may.
Your Honor, we have agreed stipulation. The 3 to 5 is consistent with the Department of Community Corrections recommendation. This is a 2013 case. Ms. Spencer Penazzola was convicted in 2014. She married and she did abscond to Indiana. She later returned to Illinois, and she was arrested in Kenosha in last year. There was an incident in Kenosha, allegation 3 contained within the sentencing after revocation packet, which was reduced to an ordinance. She represents that since the date of this conviction, she has had no criminal convictions or since. Therefore, she regrets that she did not comply with probation. She has served 97 days. As a result of this, she is age 54. She represents she does not drink or do drugs. Again, she's had no criminal convictions since that time, over a decade. Therefore, I believe that she has been reasonably and fairly punished as a result of this incident. We do not object if there are any financial or otherwise obligations owing as a result of this probationary period, that those obligations be reduced to a civil judgment against her. So therefore, Your Honor, in terms of the triad of factors under McCleary v. State, Wisconsin seminal sentencing law, I believe the needs to protect the community, to hold the defendant accountable for her failures, and potential rehabilitative needs have been met. Her plans in the future going forward are to return to the state of Illinois, to live by or with her sister, and to apply to and to address the financial obligations that she may have. She intends to specifically to apply to the Kenosha Amazon store, which to her understanding is hiring. Thank you.
All right. Thank you. Before I ask Ms. Spencer if you have any statements you want the court to be aware of, I have a very old address. Can I get an updated address for you, please?
Yes. 21557 West Birch Street, BIRCH. That's in Lake Villa, Illinois, 60046.
All right. Can I get an updated telephone number, please?
Well, my phone's been turned off for 3 months, but it should, hopefully it will still be 312-720-5583.
Thank you. And before I go into the sentencing, I am letting you know and Ms. McLaughlin know that before you are released from custody, after that takes place, you are ordered to provide your social security number to the clerk's office, okay?
Okay, not a problem.
All right. Okay, Miss Spencer, anything you want me to know or be aware of?
Yes, well, my lawyer pretty much covered everything, but any financial obligations I will take care of in a very timely manner.
I appreciate that.
I
This is a
will.
very old case, extremely old, and quite honestly, I do not understand the sentence that occurred at the time of placing you on probation and with the withheld sentence, quite honestly. It's archaic. And the fact that we have issues of worthless checks, the number one goal here is to make the victims whole. And that is to ensure that, you pay back the worthless check money and any costs associated with that. Unfortunately, it got to where it is today and where it was at the time of sentencing. And so now it looks like you owe a total of $1,199.96. And that does accumulate interest, I believe daily or quarterly or however it's calculated. So it's very important that you look at this and you try and get it paid off. Honestly, if I'm looking at this, restitution, you still owe $899.82. For the most part, these are all surcharges. I'm looking at court costs of $176. I'd be willing, if you're willing to get this paid off in a very timely manner, I'd be willing to knock off what I can, and the only thing I can knock off is that $176 in court costs and fees. So you're hoping to get a job and you're hoping to get this paid off quickly, which that's what I look at, and that's the main thing. You've already been punished now. Again, for cases like this, you rarely see jail time unless this is something that is in the person's pattern and their conduct, that they do this and that they do this a lot. So you've been punished now, sitting the 97 days that you've sat in custody. Do you have an idea of when you'd be able to get, and it's going to be approximately a little over $1,000 if I knock off what I can. Do you have an idea of when you can get that paid off?
Be realistic, man.
I'm thinking, would I be able to make payments on it, or would I have to?
Yes, I'm
Okay.
fine with that. I'm just trying to figure that out because I want to give you that incentive. Again, I'm sorry, in that I can only waive $176, but that's all I'm legally able to do. But my goal is to get this paid off, not only for the victims, but for you, because quite honestly, I will issue a warrant. You'll be in Illinois, and that could affect your life.
I understand that completely.
Could you do it in 6 months?
Yes. Making
Okay,
payments
let
like
me-
I've done in 6 months.
Okay, so 1,000 roughly. So that would be, let's say, at minimum, let's just do $200 a month payment, and you pay that to the clerk's office, to the Washburn County Clerk's Office. They have an ability to give you information on how to be able to pay it online. But so 6 months, so that's January, February, March, April, May, June, July. Let's say if you have it paid off, excuse me?
I'm sorry, can we start in February, not January?
Yes, that's fine. So that would be August. So if you have it, the little over $1,000 paid off by September, the end of September, I will waive that 176, that other 176, okay? So when you are released from custody, once you are released, go to the clerk's office, give them your social security number, and have them give you a sheet of all that you owe, so you have an idea, because then you can, when you look at it and you see the court costs, you can deduct that $176 and know that you're not going to have to pay that. You have to pay the other amount. But once you have your amount paid, that total amount paid that you will owe, write me a letter and say, Judge, I've paid it off. Can you please waive what you can?
Okay.
All right?
Ma'am.
I believe that the agreement is appropriate. You've already been punished, and there is a plan now to get all that is owed to the victims, and with regards to the courts, with the surcharges and things to be paid off. So this is appropriate. I'm going to sentence you to 4 months of jail, 97 days of jail credit. That is a time served, and you do stipulate to that, Mr. Marco? All right, he indicated yes. Okay, so he stipulates to that. And so that means a time served. Again, this has accomplished the public interest, as well as the punishment factors. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is entering a civil judgment for the amounts that you owe. You will pay the Washburn County Clerk's Office and do all that I've instructed you to do. If you fail to make a monthly payment or you fail to pay this off, the court will issue a warrant. You could sit up to 6 months in jail. It's very important that you make sure you pay that off. I believe they have your DNA, but if they don't, I'm ordering you to provide your DNA to the jail. You would have the ability to request it be expunged from the CODIS system through a written letter to the Department of Justice, not to me, to the Department of Justice. I believe that covers everything, Mr. Marco.
I believe so as well. Thank you.
Mr. McLaughlin.
Your Honor, Ms. Spencer's indicated she does not object to the court's ruling, but you have covered her appellate rights. All I would add is that she understands that the services of her attorney continue in that 20-day time period. Thank you.
All right, thank you. And she understands, she nodded her head. Thank you very much. We are adjourned.
Good day, Your Honor.
Thank you. Good day.
Good luck, Ms. Spencer. You have my card. I don't think you'll need me.
Yes, please. I've negotiated with the prosecutor to a resolution by which Mr. Dees would plead guilty to an added count of operating while visibly impaired and also an added count of distracted driving under ordinance. You'd be responsible to that. You stage the prosecutor's office would dismiss the original charges of operating while intoxicated, avoiding intoxicants, and no prevention.
All right, so I'll put the distracted driving on the C file there, okay? Sir, you understand what your lawyers just said?
Yeah.
If you plead responsible to distracted driving, that is a civil infraction. That's a 0-pointer. Do you understand that? If you plead to operating while impaired, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all those 4 points, license suspension or revocation in accordance with your record. And the vehicle could be, or might have to be immobilized depending upon your record. Do you understand that?
Yeah.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that? All right. Any questions before I ask you how you plead? To the charge operating while visibly impaired, how do you wish to plead, sir? Were you operating a motor vehicle on Telegraph near Sibley in Brownstown on November 9 of 25 at 1:51 in the morning?
Yes.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yeah. 2 beers and 2 shots.
And was your ability to operate that motor vehicle impaired because of the alcohol consumption? And if so, in what way?
Was.
Why were you pulled over by the police?
Pulled on for swerving to the turning going in the opposite direction.
Do you think you did that at least in part because of your alcohol consumption?
Yes.
Did you ultimately you were arrested? Is that right? Transported to the police station? Did you take an intoxilizer there, or did you take a blood? Was it a blood draw? And what were in counsel? This says the result with 0.13. Do you stipulate that that was an accurate reading for purposes of the plea?
For purposes of the plea, we stipulate.
Are you on probation or parole right now?
No.
Anybody forced you to plead guilty? Okay, I'm gonna accept your plea to operating while impaired. To the charge distracted driving, responsible or not responsible? I'll accept the plea to impaired driving, distracted driving, and I will dismiss on per agreement and stipulation of the parties. the operating while intoxicated, the no proof of insurance, and the open intox. I'm going to refer you for a screening and assessment. You're going to be screened and assessed today. You'll come back for sentence at a later time. Counsel, does he have any priors?
No problem, Judge.
Okay, and so. Ooh. I already arraigned him on this. I'll tell you what, I'll just continue the bond at this point. We'll give you a sentence date and then you'll come back for sentence. What do you have for me, Heather?
Judge, we do have another court to school on February 9th. I don't know if that's too far out, if we want to look for more sentencings.
Mr. Khan? I would love if you did that for me.
Yes, that's everything to be done by February 9th. Yes.
I'm gonna be more than fair with him. I'll give him credit for that day toward any jail, court work, or community service, okay? So where's that one at again?
Woodhaven High School.
Okay, at Woodhaven High. Do you know, we'll give the defendant and his lawyer a calendar, especially the defendant. So it's right down the street here, actually. But it's about I don't know, a mile and a half, 2 miles. It's all the way to Telegraph. So it's, but we'll do that. And what time does that start at, Heather?
That one starts at 8 o'clock.
So I'm going to need you there no later than 7:40 a.m. No later though, okay? You're not going to hurt my feelings if you get there earlier. You and your lawyer can go over the report. I just can't wait. And that's what we'll do then, okay? Anything else, counsel? Appreciate it. So, go down the hall, get your notice, then in the map, and then go to probation where you'll fill out a questionnaire and be interviewed, okay?
Thank you.
Good to have you here, Mr. Khan. Thank you very much. Marquis Eugene Jemison, 25B150014A and B. Sir?
Marquis Johnson.
All right, you didn't have a lawyer today, right? You went and negotiated this yourself. You waived your right to a lawyer previously, true?
Yes.
So you're going to plead to allowing an unlicensed driver to drive, and then they are going to dismiss the driving on a suspended and the expired plate, right?
Yes.
Is that what you want to do?
Yes.
If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail. Costs are all those 0 points. It won't get reported to the Secretary of State. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
Yes.
You still have the right to a lawyer. If you want one, I will give you one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a motor vehicle on November 23 of 25 that was being operated in the township of Brownstown, a 2011 Ford that was being operated on Telegraph near Pennsylvania and Brownstown?
Yes.
And you were suspended?
Yes.
And you knew that?
Yes.
And you were operating the vehicle at the time, true?
Yes.
Are you on probation or parole right now?
No.
Anybody force you to plead guilty?
No.
Plea is accepted to that charge, allowing an unlicensed driver to drive. And I'm dismissing the suspended and expired plates. You got an FAC suspension on a warrant. You gonna take care of that?
Yes, I'm in proceeding.
Pardon me?
I'm proceeding now.
Have you been there yet?
Yes, been going on for since 2000.
No, have you been there recently to take care of your ticket?
Oh, yeah, it was this, it was postponed. I was here prior, 23rd, December 23rd. And then I'm back again, January 20th.
All right. Anything else you'd like to tell me before I sent you on this?
No.
100 fines, 150 costs, 75 victims' rights fee, $50 justice assessment, 375 or 90 days. Okay? You can go down the hall and pay that and you're all set. You have that to pay, right?
Not really, but,
How much do you have?
I'm gonna call my wife, we're gonna get it done.
Well, if you need time, I don't have a problem. You have $200 with you? Is that what you said?
Yeah.
Okay, pay 200 today. And then I'll give you time to pay the rest. When can you pay the rest? Can I give you 2 weeks?
2 weeks, yeah.
January 28th, okay? Pay 200 now. And the balance, which would be 175 on January 28th. If something happens and you don't have the money, no problem, call the court. We'll go on Zoom, or you can drive up here, and I'll be glad to give you an extension. Just got to come at 8:30 in the morning on or before the due date, okay?
Sir.
You're all set. Good luck. People against Zachary D. Clement, 16M 701649. 16M. Mr. Dubin.
Good to see you again, Your Honor. Good morning to you and your staff. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Clement. Stays to my left. Please state your name. Good job.
Good morning, Your Honor. My name's Zachary Clement.
All right, we're gonna get to the bond here in a second. Where's he been? My God. Let's talk about arraignment first. Does he stand mute and waive formal reading?
Indeed, Your Honor, my client is standing with formal relationship.
All right, sir, I'm gonna explain to you your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. If you cannot afford a lawyer, I'm sorry, my apologies. You're gonna be representing him throughout, right?
Correct.
So you have the right to a lawyer today. You have the right to a lawyer at all subsequent court proceedings. And if you choose to submit the questioning with law enforcement officials, you have the right to be represented by your lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference. You have the right to a preliminary exam. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, they have to prove that the crime was committed of possession with intent to deliver marijuana, and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes, sir.
Probable cause conference should be 2 weeks from today, right, Heather?
Yes,
don't have-
there's
Oh, wait a
no
minute.
dates on the front of it.
Hang on a second. Maybe I put them away. My mistake. I don't think so, though. I don't think there's
Oh,
any
we have
dates.
dates on that. Let me double check the dates on that.
Should be
Judge.
January 28th, counsel. You're gonna be in front of Judge Hessen. And we'll make that at 10:15 in the morning.
It'll be the 27th, Judge. Sorry, that's a Tuesday.
Yeah, what am I doing? It's already Wednesday. When we have this much fun, we know it's January 27th at 10:15, and then February 3rd. At what time will she want to do that? The
Let me
exam.
check her third. She could do 11:15.
Where's your client been, counsel?
Your Honor, if I may, my client actually lives in Ohio. He's actually, all of his criminal history is from the past. That's actually cleaned up his life big time. He was not even aware of this warrant. What made you aware of this warrant?
I had bought a car dealership, just a serial entrepreneur.
You bought a car dealership?
Correct. To apply for my license to, sell cars, they said that I had an active warrant.
Where's Strongsville at?
Cleveland.
Okay.
It's a suburb of Cleveland.
All right. What else do you want to say? Anything?
Yeah, I'll just say, Your Honor, all my client's past criminal history is from around that time. It was a very bad time in his life. As you can tell, my client has cleaned up his life big time. He's an entrepreneur. He has a valid license.
I like that word, entrepreneur.
And not only that, Your Honor, I like this. He dressed up for court because he takes this.
He's got a tie on.
Yeah. And I was,
Nice tie.
he doesn't have a history of.
$7,500 personal bond. You can leave the state to go to Ohio. How's that?
Your Honor, I was going to address one more thing.
Okay.
Well, just with regards to travel, my client has had a previous trip traveled to Miami. He actually was.
Miami.
He's with his girlfriend. He's supposed to leave today and come back the 23rd.
Okay.
I was gonna waive 21 days there, but there's no need since you scheduled it on the 27th.
You can go to Miami between January 14th and 23rd. How's that? Okay. And you can leave the state to go to Ohio.
Would he be able to leave the state to go to, if for work purposes, if he informs the court prior to it?
He doesn't need to tell me. You
Okay.
can leave the state for employment purposes also, okay?
Thank you, Your Honor.
All right, so $7,500 personal bond. Again, you can leave the state to go to Ohio. You can go to Miami between January 14 and 23. You can leave the state for employment purposes. You cannot purchase, possess, or consume alcohol, marijuana, or illegal drugs. Go down the hall, get your notices. You're going to be in front of Judge Hessen, Mr. Dubin, okay?
No problem.
Have a good day. Good luck, sir. Thank you. You too.
Great day. Oh, you want to see you guys since last year, so happy New Year's Eve.
Thank you. You too. Randy Allen Tamora. 25E14857. How you doing there, Mr. Tadora? I was too easy on you, wasn't I? Your name?
Randy Tadora.
Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you've given these proceedings will be the whole true self you got.
I do.
Since you were in court, have you been arrested? I took this under 771.1 back on July 16th, placed you on probation. Any new charges pending?
No.
Any contact with the police?
No. My daughter's learned.
I'm sorry?
My daughter's learned a lesson that day, sir.
All right. Case dismissed. You're compliant. Motion to the prosecutor. Congratulations. Best of luck to you. Thank you. Abdullah. Okay. Mohammed M. Hawakma. 25B149-772 Good morning.
Judge, if I may, the translator on that case left? That's correct.
Why?
He said he'd be available by Zoom,
Why did he leave?
because apparently I had him as a no-show. But he did leave about an hour ago.
Your Honor,
How are you today, by the way? Nice to see you.
good to see you, Your Honor. Sharon Payne appearing on behalf of Abdullah Hawatman. For purposes of today, I believe my client wishes to waive the services of the interpreter. If you could have the interpreter present for the pre-sentence investigation and the sentencing. Up to the.
Let's call Heather, call the interpreter. I don't understand why he left. I mean,
Your Honor, he was here at 9:35. The defendant was here and he had court at 10 at another quarter. So he left. Yep.
you gotta be careful when we have interpreters. They charge us a lot of money, you know what I'm saying?
And originally, this case was scheduled for 9:30.
Okay.
Changed the date, and I think the time got changed, and my understanding was today it was 9:30 as well. And my client was here.
He never checked with me around.
Well, it's understandable. It is scheduled for 8:30. I mean, he doesn't speak English. Geez. Where's your office again?
Southfield.
Heather, are you trying to call the interpreter?
I don't have the contact. I'm not sure who the interpreter was on this. This was something that was scheduled prior to me coming into your court. Judge, I'm not sure if there's something in the file.
Yeah, if you have it,
I have it. It's back at the office. Do you want me to go grab it?
please. Yeah, it was scheduled for 8:30. Just, I don't even, if he can't speak English, I don't want to take his plea without the interpreter.
I'm sorry, you're not here.
No, I'm sorry. If he can't speak English, I don't want to take his plea without the interpreter, right? So why don't we just adjourn it?
Okay.
And you just got to be here at 8:30 next time.
That'd be a problem.
Okay, so we'll, I'm not even going to arraign him. Does he have any priors?
No.
What was the blood or breath result here allegedly? The blood or breath result here allegedly?
The blood alcohols are.
Yes.
0.13.
Okay, and he has no priors. We're gonna set a new arraignment and pretrial date. We need the interpreter. I mean, if he's got court at 10, you're gonna be waiting around. I don't wanna have you wait around. I'm sorry about this. We're gonna, give me another date if you would, Heather, and we'll do it in a couple weeks or so.
Okay, Judge, we could do January 28th at 9:30.
Is that good with you?
That's good with me, Your Honor.
At 9:30, and then just make sure the interpreter, I really wish he would have checked in with me. I saw him floating around the back today, but I thought I saw him floating around the back yesterday too. I could be wrong about that. So I'll just keep everything in the file again, I'm not gonna, just tell him I don't want him to drink alcohol, right?
Understood.
Okay? If you can write that, or whatever you can do. Go down the hall, get your notice, you too. Take care. Thank you.
Yeah. Thank you.
Good luck. Amanda Jo Mathis. And it's U5B150098. All right, man. Your name?
Jerome Matthews.
You should have been a lawyer. You got a good deal here. Huh?
I prefer medicine,
Prefer medicine? Are you a doctor?
surgical technologist.
Okay, you're gonna plead to impeding. They're gonna give you, I'm sorry, distracted. They're gonna dismiss the original charge of driving on a suspended, true?
Correct.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'm gonna accept the plea. I'm going to assess fines and costs of $175 and pay that today, ma'am?
175?
Correct.
Yes.
Okay, go down the hall, take care of that, and you're all set.
Thank you.
Have a great day. Good luck. Did you, do you have Mr. Hayesh's case or counsel's Casey? You have those?
Morning, Judge. I still have to talk to Caitlin. I just stepped up.
Okay. No problem.
I'm putting it in right now with Caitlin, Judge.
Perfect. Thanks,
Okay.
Heather.
Judge, you still need that number?
You know what? Just get, I'm not gonna, I didn't want to, the guy had to go to another courthouse and I just felt like, why don't you just, John, just put the interpreter's phone number in there for the future, will you please? John, I'd like you to call Rosio, tell him I need them on this case, Paul. Detective Darsniak or whoever's going to stand in here, please. Shamarian Dwayne Christopher, 25B149709 A and B.
Good morning, Judge Massengate, apparently has Mr. Christopher.
Good morning, Mr. Christopher. Your name?
Morning, Shamari Dwayne Christopher.
All right, so what are we doing on this one?
Please. Judge, today's date time set for pre-trial in this matter. We've reached a resolution with the prosecutor's office. They are willing to amend the EWLS down to allow an unlicensed driver to drive. I did talk to Mr. Christopher. He wants to avail himself of the agreement. Judge.
And he's also going to plead responsible to failure to stop assured clear distance with them dismissing the suspend, right?
Correct.
Is that what you want to do, sir?
Yes, sir.
If you plead to allowing an unlicensed driver to drive, that's 0 points. It won't go on your record. Possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, sir.
If you plead to allowing an unlicensed driver to drive, those are the possible penalties. If you plead to wait a minute, let me start over. I'm sorry, I'm writing here. If you plead to allowing an unlicensed driver to drive, I explain the penalties. You understand these?
Yes, sir.
If you plead to failure to stop assured clear distance, that's a civil infraction, 2-point violation. Do you understand me?
Yes, sir.
If you plead to those two, I'm dismissing the suspend on motion of the prosecutor. Do you understand me?
Yes.
I can't hear you.
Yes, sir.
Did you sign an advice of rights form today and read it and understand it?
I did not sign one today, but the last time we were here in my bank, I did sign it.
Gotta have you sign it. Sorry. Why, let me just verbally advise you again. You have the right to remain silent. You have the right to a trial by court or jury. You have the constitutional right to a jury trial. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to testify or remain silent. If you remain silent, that silence would not be held against you, but you do have the right to testify. If you plead guilty, you're giving up all those rights. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
All right. So if you plead guilty, we're not going to have a trial. You understand that?
Yes, sir.
To the charge of allowing an unlicensed driver to drive, how do you plead? On October 31 of 25, were you operating a motor vehicle on Sibley near Inkster in Brownstown Township, 7:19 in the morning? and you allowed somebody to drive that was unlicensed, and that was you, correct?
Yes.
To the charge of fair to stop, assured, clear distance, how do you plead?
Responsible.
And are you on probation or parole?
Yes.
For what?
I'm on probation. 2.5 years back, so I'll.
Just tell me for what?
In the movie.
You understand by pleading guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this misdemeanor plea and conviction.
Yes,
You still wish to plead guilty?
yes,
Anybody force you to plead guilty?
no,
Okay, I'm gonna accept the plea to that charge, accept the plea to failure to stop, assured, clear distance. Look, I have to set a sentence date because the victim has the right to appear here, okay? Since you were committing a misdemeanor at the time of the civil infraction. So they would be entitled to restitution if they don't have insurance or it isn't covered. Depends on a multitude of factors. But Heather, we need to make sure that the victim is notified, and then you can give me a sentence date on a Brownstown docket.
That will be January 28th at 9:45.
Okay? January 28th at 9:45, okay? You understand that, sir? All right. Are you talking to your lawyer or are you talking to me?
I was talking to my lawyer. Judge, Mr. Christopher was asking if it's possible that he could come in earlier than that.
I have to set it on, I have to set
Not the
it.
date, but the time.
Yeah, we can do earlier. Geez, somebody wants to come earlier. It's amazing.
Could I work on the farm?
That's fine. Can you come at 8:30?
Yeah.
I'll do 8:30 for you. You'll be here at 8:30 though, right?
Yes, sir.
Good enough. Go down the hall, get your notice, and you're all set. I'm not ordering a pre-sentence or anything, okay? Thank you.
Thanks. What was the name on that?
Christopher Hall. Call him. Jennifer Renee Pauses. 25B149163. Your name, ma'am?
Office.
All right, so this is a parental responsibility. Prosecutor moves to dismiss. One of the three vehicles hit with rocks was damaged, but victim did not respond. Prosecutor's letter or phone call. Per defendant, son has been punished for incident. How old's your son?
9 years old.
Yeah, that's not good. I mean, I hate to see you guys charge you with this stuff, though, on this kind of thing. If you're not sending them to school, we're not guarantors of our children's behavior, but I hope you did punish them. Have a nice day. Best of luck to you. Thank you. Whittle, Timothy Jamie Whittle, 25B148379 A, B, and C.
Good morning, Judge. Matt, get my apples for Whittle.
All right, let me just, give me 1 second. So defendant pled guilty as charged to possession of a controlled substance.
Yes.
He had cocaine, and then he gave the wrong name, so false information. And also, let me just make sure that, yeah, that was the plea to that charge. And then also he pled guilty to driving on a suspended. So those are the convictions. Have you had a chance to review the report with them, the pre-sentence or screening and assessment? And are there any material additions or corrections?
We had a chance to review the report, Judge. With regard to the recommendation, he has no corrections, omissions, or deletions. I would note, however, Judge, Mr. Whittle is 24 years old. He does own his own business. He earns about $500 a week from that business. He's a general contractor. He just currently got engaged. He does have one daughter, just 7, he shares custody with the child's mother. He did graduate high school, Judge, in 2019, and he is currently enrolled at the Washington Community College, working towards a degree in finance. This is Mr. Whittle's first drug-related conviction, Judge. With regard to the with the probation term, I've gone through with him, and he's aware of all the requirements that
not required from the judge, so we'd ask the court to adopt the recommendation.
Anything, Mr. Whittle?
I want to say that about my Melissa. I want to say that I'm Melissa. I was young at the time, and I've been maturing 3 years, trying not to mess up no more. Things that I messed up before.
I'm disappointed you don't have more warrants.
Judge, according to Mr. Little, they take care of the one at the 48th District Court. I don't know why that's not reflected on the current lien. But I did make him aware of the other outstanding ones, and he assured me that he will take care of those in a timely manner.
You're going to college and you want to go into finance and you're treating courts like they're a.
I'm the finance degree just so I can get into law school. I don't get a lawyer.
Well, you can't go to law school with this kind of nonsense going on. Are you kidding me?
Everything needs to be in by February 6th. That's all of them.
You seem like a nice kid. What are you doing here? You're acting like a fugitive, though. Well, come on. You gotta analyze better than that. I mean,
it's not an excuse, but my mom passed away a couple years ago, and ever since she passed away, I was making bad decisions. Like, I finally got my head on straight now.
Is your father in your life?
I'm in contact with him. He doesn't stand me.
He what?
I'm in contact with him, but he doesn't stand me. He's in Missouri.
I'm sorry about your mother. You seem like a really nice kid. Don't do stupid things, right? They come back and haunt us. They really do. I mean, you can't do this, you know? How'd you crash your vehicle?
I was driving on 75 and right by the big exit right there. Somebody drove past me and hit my back tail bumper. And then it was like icy out. So instead of like regularly swerving into the ditch, it flipped over.
Who's the prosecutor in this? Were there other cases involved in this? How many cases?
Yes, ma'am.
Yeah, I mean, what other files did he have? Can you tell me, Heather, how many other files he had? She didn't make him plead to all 3 as charged.
With the A, B, and C files, Judge, is that what you're regarding?
I got 258-148-379, A, B, and C, and I'm just asking, arising out of this offense date, what else did he get charged with, if anything?
On this date, let's see.
December 1 of 21.
Let me look. December 1 of 21. He has a 21 case, but it's not a. Gosh, he's got a few things here. I'm looking, Judge.
Sadie. Let me just have Sadie pull this up real quick. I want to see his whole record. Can I?
Yeah, because I'm
see
seeing
it on
stuff from May of 21.
Can you get that on my screen? There we go. Yeah. Oh, thank you. Call in the prosecutor, will you? Oh, wait a minute. I'm sorry. He had. Wait a minute. Yeah, these were 25 cases. He just didn't show up on them. So she dismissed a no ops and no proof. Your appearance, Mr. Whittle has been very, 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 let's just call it irresponsible. He got 13 warrants out for his arrest. But I think he's eligible for 7411. You willing to offer him that?
As long as it's eligible, Your Honor. I don't think I've reviewed the file.
Pardon?
I don't believe I reviewed the file.
Yeah.
Because it was sentencing.
It's a sentencing today, and you plot them out earlier. Let me just double check his criminal history here. I mean, what are you, I have no business sticking my nose in for you. You know that? Are you listening to me, Mr. Whittle?
Yes, sir.
I have no business sticking my nose in. We're acting like a fugitive. You don't show up. He tells me he wants to go to law school. I mean, you gotta. I'm just, what?
It's gonna be up there, but
Well, grow up. You gotta grow up. I'm willing to take it under 7411 if you want to move for that. You want to look at anything in here?
Problem was, it was a global resolution. Mr. Whittle had another exact same case, so I dismissed that possession charge entirely.
Where was that at?
I think it was also this year.
Do you have another drug case?
no, Your Honor.
I don't think he did. Not in here, not in this court.
If I could just review.
I'm gonna let you review the file, okay? Review the file and tell me what you think. Mr. Whittle. Grow up. Here, Sadie, can you hand her those, please? Do we have Grosjean out there yet? People against,
I let him know, Your Honor, I told him to get it practice.
Yvonne John Regner, 25B149897.
Judge, good morning. Vincent Hayes on behalf of Mr. Redner, who's not present, who's present, I'd ask the court to waive.
Okay, no problem. So you're going to plead to distracted driving on this? You're authorized to enter that plea. The careless driving will be dismissed, right?
That's correct, Your Honor. I have agency and authority to act on behalf of my client. Ask the court to adopt that.
What's your client doing? She wasn't drunk, but she drove into a mailbox. They charged her with careless, right?
No, he made a boneheaded decision. I'll tell you, Judge, I know him. I know his uncle, who's a sergeant with the sheriff's department, and I know both his father and his uncle, who are twins. They let into him. He's had the business on this one.
All right. So the charge of distracted driving, responsible or not responsible on his behalf?
Responsible, Your Honor.
I'll accept the plea. The careless is dismissed. 195. I'll give it until January 21. Okay.
Excellent, Judge. Hey, my best to you and yours. Take care.
You too. I saw you at Mr. Flood's there at the party, at your party too, I guess. And
Yeah.
but I didn't get a chance to talk to you. I saw you across the room. Nice to
I
see
was in
you.
1,000 directions. Next time we're gonna get, we'll tip it a little bit.
Have a
Give my
good day.
best to Sean and
Thanks.
everybody else. Take care.
Bye now.
You too.
Are you out there yet? Tell you what, I'll arraign Mr. Hackett, and then they should be here. If they're not, I'll have you sit down before I hear bond arguments. Christopher Thomas Hall, 24I-721000. Oh, come on up. I didn't see you back there. I'm sorry. If you're around here, I wouldn't mind
Excuse me.
doing that search warrant.
Walked outside.
Hey, I'm used to it. These guys all come to court and they sit in the parking lot. I don't get it, or the hallway. I've never seen anything like it. It's like there's a. So maybe I can do that search warrant for you, okay? Mr. Hall, come on up.
Sorry, I didn't restroom.
No problem. Christopher John Hall, 24I-721000.
That's not my middle name.
Or Christopher Thomas Hall. You know, when you get old, you start to misread things like that. Okay, I'm sorry. 24I-721000. Mr. Hackett, your appearance.
Good morning, Your Honor. If it pleases most honorable court, William Hackett, P65962 on behalf of Mr. Christopher Hall.
Your name, sir?
Christopher Thomas Hall.
Detective?
Detective Delpez.
All right, so I have here what? OWI-3 and the next count of OWI-3. The first is high BAC. So for purposes of arraignment, does he stand me waive formal reading?
My client will waive the formal reading. My client will stand mute as the court does not guilty plea on my client's behalf.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You also have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand them?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss the case with the prosecutor. At the preliminary examination, they have to prove that the crimes were committed that you're charged with and that you were the one who probably committed the crimes. If they prove that, you'll be bound over for further proceedings to the circuit court. Do you understand that?
Yes, sir.
All right. Probable cause conference, you're gonna be in front of Judge Heston on this. It's gonna be January 27th at 9:30, preliminary exam, February the 3rd at 11, okay?
Judge, on the PCC conference, I have 3 matters scheduled that morning.
Where at?
I'm in Macomb County at 9 a.m.
Do they let you do them by Zoom?
Pardon?
Do they let you do the?
I can do Zoom, yes.
Well, why don't I make it a little bit later in the morning? And if you can get done with these, we can make it 10:45 if that's okay with you. If you think you can do it.
I'm in Carroll as well in the afternoon, so that would be very good, Judge.
Yeah, 10:45, January 27th, February 3rd at 11. Okay, let me hear your argument for bond here. Where's he been? Why didn't he show up? This warrant was issued.
I included with the advice of rights, a letter from Redemption Road Recovery Center for Men in Kentucky. That's where my client has been since January of 2025. He's been in recovery at Redemption Road. I also.
Am I reading this letter from the lawyer, Paul Baker?
Paul Baker he's affiliated with Redemption Road. My client has been working with his construction company while he's doing residential recovery. He's completed program down there, and he made arrangements to come back up here. And
does he live in Kentucky?
He has been living in Kentucky since January of 2025 when he checked into the Recovery Center for Men.
When did you find out about this warrant, sir?
After I was already there, Your Honor.
I know, but you should have called here and had us Zoom do this.
Because I had contacted the court when I was contacted by my client's father, just prior to him finishing the 6-month program before he went into recovery. Recovery living. And he just got to the point where he's strong enough to be able to lead and to be here. He's had a year of sobriety. And he wants to take care of this and move on with his life, Judge. He came up here voluntarily.
But he's still, okay, he's listed on Grange Road. He's not living on Grange. He's living, do you have a father or mother that lives there by chance?
My girlfriend lives there, and that's where I was gonna have the mail sent. I'm in contact with her because I don't have a residence here. I have residence in Kentucky. Then I plan to stay until this is completed and I can go back because I can't, there's no means for me to go back and forth.
Wait a minute, you plan to stay in Kentucky?
Permanent. But while the court proceedings are going on, I was going to stay here.
I see. Okay, what else do you want to say?
Judge, he's been working, he's been sober, he's been tested quite frequently.
What does he do for a living?
He was doing construction work down in Kentucky, building houses. And Mr. Baker owns the construction business. Since he's been here, just before Christmas, he's been going to Thrive, which is
Sir, you gotta take your hat off.
Christian Recovery Center.
All right, I've heard enough. I'm gonna give him a personal bond here. Sir, I'm gonna give you a $10,000 personal bond, but there are strings attached to it. You cannot leave the state without consent of the court. You can leave the, by the way, you don't have an objection to that, do you? You cannot leave the state without consent. I'm going to let you go to Kentucky without consent. You cannot violate a law. You must appear in court as directed. We'll send your mail, Heather. Make sure you make a note of that to the Grange address, since that's where he's going to be living during the pendency. Also, you have to go to AANA at least 3 times a week. That's going to be in person. And also, you have to be on a SoberLink device by the end of the day. Okay. So they're going to explain to you where to do that, where you can get that. You're going to have to go out to Livonia. So you have to be on a SoberLink device by the end of the day. It's a machine you're going to blow into 5 times a day. Okay. And that's it. What did you want to bring up?
Judge, my client has been involved with this Thrive Christian Recovery Group, South Point Church in Trenton. He really didn't have a whole lot of success with the AA program. This is a recovery program that's Christian based, that's similar to what he's.
Okay, what did you call that again?
Part.
What did you call that again?
It's called Thrive, and it's a part of South Point Church in Trent. Direct case. Tom is associated with.
I'm just going to say, or any combination of AA/attendance at the Thrive program. Okay. So 3 times a week you have to go though. Okay. Either way, you understand? Is there any problem with that? Do they have it 3 times a week?
No, they do not. They only have it 1 time a week.
Okay, so you're going to have to still go to AA twice a week then. Okay. All right. Good luck. Anything else, Mr. Hackett?
No, Judge.
You'll be in front of Judge Hester when you come back. If you want to wait around, I'll take a couple, please, and I'll do the search warrant.
No problem. Be in the room. I just want to remind you that he does not have a valid license, so, and his places that he's going to make sure he has a right.
Yeah, you got to revoke the license. You realize that you can't drive, right, sir?
Yes, I do understand.
Okay.
He hasn't been driving.
I'm not saying he was. I'm just reminding him. All right. Good luck. Thanks.
Thank you.
Thank you.
And I'll
Teresa,
get the Zoom information at the county. For the
PCC, yes. Because they're going to give you Judge Hessens.
Thank you very much.
Okay, thanks. Teresa Lativia Hurst. 5B149712A and B. Okay. How you doing, ma'am? Your name? You don't have a lawyer, right? Who's your lawyer?
Sure, you have to sign a piece of paper if he goes to know.
All right, well, I'm gonna have to wait for him, okay? So why don't you have a seat right there at the table, and when he walks in, call your case. Height? Joseph Height? You have a lawyer, sir?
It was Mr. Baldwin, but,
Did you talk to another lawyer today?
yeah,
Who's your lawyer? What's his name or her name?
I think it's the same company.
Same guy, I know.
Okay. We're just gonna wait until he's ready, okay? Thank you. We'll pass these cases. Stay seated, everybody. As soon as I get something, they're ready to go out.
So, great. Yeah. What? I didn't know you were ready. I was out of courtroom. I didn't know I was ready either. Okay. I'm here. I can't be in there 24/7. You should be. I should be, yeah. Well, you should be reasonable.
Was here. Today.
Good morning, Mayor. Please, the court attorney Damian Cash, P number 85852 on behalf of Mr. Taylor Byer. Mr. Byer, state your name for the record.
Taylor Martin Byer, Your Honor.
All right, date and time for sentencing. Have you reviewed the report?
Your Honor, yes, we've reviewed the PSI report. I have no additions or changes or deletions, Your Honor. I just do at some point want to discuss the bond violation that Mr. Byer had in the report that I recently received.
Well, go ahead.
So, Mr. Byer, I called records at Bear River Treatment Facility in around about Traverse City area. He was admitted for treatment on November 24th. That is the reasons and the explanation for why he was not able to test. I do understand that he was in contact with, at times, the probation department to inform them that he was in treatment. I'm not exactly sure how those conversations detailed. However, he was in treatment. He completed December 23rd, and they confirmed the records to me this morning, and I also reported those records to your court as well, Your Honor.
He completed Bear River.
He completed Bear River, yes, Your Honor.
I think I'm not going to find a violation because I think that the issue is potentially that there wasn't a release information. It wasn't anything that this gentleman did. I was a circumstance where information was just not flowing
back and forth
yes, like it should have been. So I'm not going to find a violation of it.
Thank you, Your Honor.
Doesn't seem to be a violation. He's in treatment. So, all right.
He owed him some flowers and candy as I promised him this morning for his record.
Okay. Anything else?
Other than I'll just briefly allocute. I've been in contact with his family, his brother, and they informed me, and along his siblings. They are, I'll say, very interested in seeing his growth and his continued development as he continues to go through treatment. I believe it is very serious to him as well, as he's admitted to himself. He's explained to me multiple times that it is very serious to him to get through this treatment process to better himself, and that really he just want to get back to being a productive citizen and back to work, Your Honor.
Yes, Your Honor. Sir, anything you want to tell me?
I want to say thank you for everything you did, because it actually helped me in my life to get my life on track. And I only want to do the right thing. I want to be the best dad I can be for my son. And I just want to be the best person I can be. And I just want to say thank you for helping me with my journey, because I'm on the right path. And I just want to say thank you.
You're welcome, sir.
Thank you.
Ms. Blair, just so that I can make sure I'm understanding this, the proof of treatment.
Your Honor, I was not able to
Fair.
obtain that information because there was no release of information.
Got it.
However, it was brought to my attention when Mr. Byer was arraigned that he advised the court that he was in treatment, and they had something of attendance but no completion. So I know he represented that he did complete it. I just was not able to.
Right, and I think.
Can I say something?
Was this the one that we received that indicated that? Or was that another one? Was another one. Okay. I guess I don't have the proof of the treatment yet. Myself, but
last week when I was here, I gave my completion to Judge Reese, and I actually have my completion in my file.
You gave it to who?
Judge Reese. Is that her name?
Well, we don't have a Judge Reese.
I gave her the copy last week, and they made a copy of it. It's actually in my folder.
I was to say, they're not from Bear River.
Yes.
The records I received today will be the most, I would say, up-to-date records that was released this morning, Your Honor. And hopefully that is enough to, because it states on there.
Yes, they
successful
can. Well, which records are you talking about? I actually have it. I see the verification of the discharge letter from Bear River. I see it now.
Okay.
Indicating that he has successfully completed the program.
Okay.
So I have it. I see it. It was one of the other papers that was on there. Okay. And that's the treatment you were talking
Correct.
about. Okay, very good. All right.
Your Honor.
You're welcome. So I will send to the court $125 statutory fee. I'll order 90 days in jail, credit 61 that he served. The balance of that is suspended.
Thank you, Your Honor.
Okay, so I'm changing that. Good luck to you, sir.
Thank you, sir, and you have a wonderful day. Thank you.
Thank you.
Thank you. Oh, yes, I will, of course. I will not.
Court calls the case, People versus Wayne Rankin.
Carolyn Foster Tucker on behalf of Rankin.
Your name? Wayne Rankin. All right, go ahead.
And Your Honor, we have had a chance to review the pre-sentence report. We have no additions, corrections, or deletions. We would ask the court to follow the recommendation. Mr. Rankin did indicate that he needs a payment plan for the restitution and the fines and costs. He said he can make a payment by Friday of $200.
Yeah.
And then he believes he should be able to do $200 monthly payments. Is that right?
Yes, ma'am. Anything you want to say, sir, before I impose on?
Just, no, I don't really have much. I just take full accountability for my actions. Just made a bad error in judgment at the time. I just got back to working for a Bill property. I was laid off, so that's why I'm not being able to pay anything today.
Sent to the court, $400 fines and costs, $3,484.87 restitution to the victim in this case payable through the court. I'll order 93 days suspended. As to the payment of the fines and costs and restitution, that's to be $200 per month beginning January 16, 2026. I will set a review hearing that will be June 10th, 2026 at 9 a.m. to verify compliance with the payment plan.
Okay.
All right.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Deanna Conrad.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Conrad. Ms. Conrad, state your name for the record, please. Deanna Conrad. Today is the date and time set for defendant today. Do ask that the court adopt the recommendation that Ms. Conrad has been in custody for quite some time. I would ask for a payment plan to be established with probation on the fines, so she can get out and get back on her feet before starting to pay those.
Anything you want to say, ma'am, before I impose sentence?
No.
And you know why you're here, right?
I do.
You gotta do stuff different.
Yes.
Right? The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance and recommended treatment. So therefore, the sentence of the court that you are placed on 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is to be paid in a payment plan as established by probation. There is to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's input panel attendance to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You are to report to probation on January 20th, 2026 at 2 p.m. That is an in-person. Right? And then you're to report as directed. I'll order 93 days in jail, credit 47, balance is suspended. Right. Thank you.
Thank you, Your Honor.
Calls the case, People versus Rex Jenkins.
Incarcerated in a facility in Ohio. I do not believe he was writ for today's hearing, but I was able to meet with him and go over the recommendation, and he would be asking the court to follow it even without his presence.
All right, and so you're indicating that you wish the court to sentence him in absentia on this violation.
Yes, Your Honor, and I did speak with him directly yesterday, and he gave me permission to proceed in that manner.
All right, and so he admits to the violations of probation. In absentia, will sentence the defendant to 365 days in jail, credit 365 served. He is to pay $545 outstanding restitution balance that will be sent to our collections department. I will waive all remaining terms, discharge him from probation. Thank you. Court calls case, People versus Leo Stringa. 2 cases.
Assistant Public Defender Natalie Pate, on behalf of Mr. Stringo, stands to my right. Please state your name for the record, sir.
Leo Stringer.
Thank you, Your Honor. Today is the date and time set for both cases. We have reviewed both the pre-sentence investigation reports and do not have any material corrections. And as to the recommendations for each case, we would respectfully request the court follow them.
Is there anything you want to say before the court imposes sentence?
Oh, yeah.
The case ending in 1106 sends the court $125 statutory fee, $251.80 restitution to buyers payable through the court. That will be due 60 days after release. I will order 93 days in jail, credit 62 days. The balance the defendant is due. On the other matter, that ending in 0612, $125 statutory fee, $107.94 restitution to TJ Maxx payable through the court. That will also be due 60 days after release. And then I'll order 93 days jail, credit 62, the balance he is to serve. Thank you.
Thank you.
Thank you.
Court calls case, People versus Eric Mays.
Assistant Public Defender Natalie Pate, listed on behalf of Mr. Mays, who stands to my right. Please state your name for the record, sir.
Eric Mays.
Teresa Claire on behalf of probation. Your Honor, Mr. Mays is before the court today for a violation of probation hearing. I know that the recommendation that I presented to the court today is a jail recommendation. However, I've had a chance to speak with counsel and Mr. Mays today. I would ask the court at this time, I would like to give Mr. Mays an opportunity to meet with me to provide what he has been doing. I think that treatment is a big component that Mr. Mays needs to accomplish. I would like to see where he is with that. Given that, I would ask the court to adjourn this violation hearing to February 25th, 2026. That Mr. Mays be placed on a scram tether today. My office would do the referral for that, have it sent over. And that he stay today and meet with me after I get out of court to go over and see what. And I would also like Mr. Mays to know on the record that he is getting a very, very big break from me. So I expect that the court order to be followed. And then we'll see where things are at the February 25th BLP.
Thank you, Your Honor. That is all correct that Ms. Blair stated, and I would like to thank her for this, what's the word I'm looking for? Edited recommendation. I apologize, Your Honor. And Mr. Mays is also very grateful for the opportunity to get back into compliance with this. Obviously, we have absolutely no objection to the scram tether or anything like that. We would ask the court to adopt that recommendation.
Is there anything you want to say?
Just that I looking forward to, prove to the courts that I'm on my way to my rehabilitation, that I don't want to be able to talk to my family or my workers that I have that work for me to complete the jobs that we have going, and to show that I'm a good citizen of society.
All right, I'll go along with what probation is now recommending, but I'm going to let you know. Ms. Polera gives people a chance that's consistent with how this court feels. If you mess this up, I'm not going to be because the final decision is mine. I'm not going to at all be listening to any kind of break for it. You will just do time. Sure. Am I clear?
Perfectly clear.
I'll adjourn the violation of probation hearing to February 25th, 2026, 9 a.m. The defendant is ordered to meet with probation today, immediately following Ms. Blair's attendance in court today. The defendant is also going to be ordered to report to community corrections for placement on a scram tether today. All right. Okay. Thank you.
Thank you, Your Honor.
Put on to my office, that referral for the scram tether. You can go over and get it put on, and then I'll meet with you after.
Okay. Court does call the case of People versus Legary and Thomas.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Thomas. Mr. Thomas, state your name for the record.
Legary and Thomas.
Your Honor, this is the show cause hearing for money owed. When I spoke with Ms. Thomas a few days ago, we were going to ask for an adjournment. He's was in custody, he's out of custody, he's getting back on his feet. However, now that he's back in custody, he's obviously not working. So I just asked to set this out.
Well, what I'm going to do is I'll just refer this to collections rather than bring it back and forth. So our collections department to deal with it.
Thank you, Your Honor. Mr. Thomas was asking what his bond is on this case, if the court has it. I believe it was a PR.
Well, no. Posted 100. Now, his bond was denied. Then, yeah, so his bond was actually 10,000, 10% on April 30th. Then on September 22nd, 2025, the magistrate lowered it to 1,000, 10%, which he posted.
Okay, so he's not being held on this case then. All right.
Thank you, Your Honor. Thank you. Court calls the case People versus Larry Evans.
Mr. Evans. Your Honor, Mr. Evans has been actively texting me. He is on the bus and he was gonna appear on Zoom today. He's been texting me since 8:30, trying to get on Zoom in about an hour.
He's on a bus?
He is. And
Where?
I look like, oh, literally just now, I'm in the building. Sorry. But 14 minutes ago.
So I can't issue a bench warrant?
No. Yeah, because.
He's in the building? Like where? Where?
I can go.
This is a big building.
It is. He's probably either about to go through security or just did. And I will say.
You're doing that Nebo look toward the door, hoping that he's gonna walk through at any moment.
I hope so, but I believe him. I will say this.
You do believe him?
Yes, Mr. Evans has never lied to me. He's talked to me a lot. So, never lied to me yet. This would be a weird first lie. Because I can so easily prove him
I don't
wrong.
think he's in the building.
I will text him. Hurry. Hurry.
Where? He's in the building. I'll pass it.
Thank you so much, Your Honor. I do appreciate it. Good to be yesterday too. We're prepared to see.
Court calls the case People versus Carlos Mack. Say again. Oh, okay. Oh, here she is. Ms. Rushing?
Judge.
Good morning. Want to state your appearance?
Yes, Judge, can you hear me?
Yes, I can hear you.
Okay. Looks like I was having some connection issues. I apologize. Your Honor, Sydney Rushing, appearing on behalf of Mr. Mack this morning. And I'm standing in for his attorney of record, Mr. Byrd. Mr. Mack, is that okay with you?
Yes, ma'am.
All right, state your name.
Carlos Mack.
And can you state your name for the record?
We got that. I have here that an alcohol screening assessment was completed and defendant is currently being held with no bond because of his sober link violation.
That is correct, Your Honor. It's my understanding that to complete his assessment, he cannot do the portion that he has to complete yet in the custody. I believe that there is a request and agreement to allow him to be released on a scram tether so that assessment can take place and that his sentencing can proceed forward at the next date.
All right. Okay. I will allow the defendant to be released from custody with a scram tether that must be fitted on the defendant prior to release. Ms. Blair, were you going to do that referral or did you want to?
I can do it, Your Honor, if you'd like, or,
Ann already
Got
got it. All right. And that will be prior to release. Defendant is then referred to Von Swartz for an alcohol screening and assessment. And the sentence in this case will be adjourned to February 11th, 2026 at 9 a.m. Thank you.
Thank you so much, Judge. Happy New Year.
All right. Yes, and to you. My staff was just saying that you're one of their favorites. I can't say I have.
Well, they're my favorite, so it's mutual.
And that they said that they hadn't seen you.
And Judge, I might not be your favorite, but you're one of my favorites too. So I'll put that out there.
I didn't say you weren't. I just said, all right, very good. Okay, great seeing you. Take care. I don't know if he has that. I have to set his bond at a PR. It was denied. It's being held because it's a violation.
So you want a PR?
A PR. Court calls the case, People versus Jessica Lopez.
Good morning, Assistant Public Defender Lauren Cooney on behalf of Ms. Lopez. Ms. Lopez, please give your name to the record.
Jessica Lopez.
All right.
Teresa Claire on behalf of probation. Your Honor, Ms. Lopez is before the court for a review hearing on a prosecutor deferred sentence. Ms. Lopez has had some struggle financially. Her family's been helping her out with her rent and things like that. She has not paid the monies in this case. She did complete the theft class, however, and is working on the community service hours. Ms. Lopez also has, a child that she's trying to take care of, and she is working. Given all of the circumstances with Ms. Lopez, probation is recommending that the court extend this prosecutor deferred sentence for a period of 6 months, that Ms. Lopez make $100 payment by January 30th, 2026, then $100 per month thereafter, that all other conditions continue, with a next review hearing being set July 8th, 2026 at 9 a.m.
All right. Ms. Lopez, can you make that payment by the 30th?
Yes, actually, my brother's been helping me with a lot of my bills. As this is actually helping me a lot. He's helping me with a lot of things, so I stay on track and not do any mistakes again like this. It's just really hard. I'm a single mother, and he said he's willing to help me with anything I need. So as long as I continue working, it's so.
Being one myself, brothers are good people. What I'm gonna do is I will extend the prosecutor's deferred sentence for a period of 6 months. You're gonna pay $100 by January 30th, 2026, and $100 per month thereafter. I'll continue all of the terms as previously ordered. I'll set a review hearing for July 8th, 2026 at 9 a.m. All right, Ms.
Yes,
Lopez?
sir.
All
Thank you
right,
so
good
much.
luck to you.
Thank
You're
you so
welcome.
much. Bye-bye.
Bye-bye. Court calls case People versus Christopher Mary.
Teresa Claire on behalf of probation. Your Honor, Mr. Mary was scheduled for a review hearing on a prosecutor deferred sentence. He did complete all terms ordered by the court, and he did waive his attorney. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge him from probation with improvement.
It's a whole nother issue. Anyway, not you then say to you.
Appointed. I get one appointed. Ms. Caruco has an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed. Who are we appointing?
Bruce Hurst.
H-U-S-T. do find that you're indigent for the purposes of hiring a lawyer. I'm going to appoint Mr. Huss to represent you. You have his contact information there. We're also going to send him an email today that lets him know that he's been appointed. And we're going to set it for a final hearing in probably about a week to 10 days. Anything you want to tell me today?
No, Your Honor, I'll wait till next week. Thank you.
Okay, I do find there's probable cause to believe you have violated the terms of your community control. I'll see you in a week or so.
Yes, sir. Thank you.
All right. Next is the case of the state of Ohio. This is case number 23 CR 40108. Present before the court is Ms. Gates, right? You're Ms. Gates, right?
Yes, sir.
We also have Mr. Harris from the prosecutor's office, and we have Officer Ruff and Ms. Wilkerson from probation. We are here today, Ms. Gates, because I've received a report that alleges you have violated the terms of your supervision. You didn't check in when you were supposed to. You were positive for marijuana throughout. We have positive drug tests for children's services in November and December for cocaine, marijuana. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you.
No,
Do you want to be represented by a lawyer?
No, thank you.
Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated probation?
Yes, I admit.
Well, actually, this is an ILC violation, right?
Yes, Your Honor.
All right. Do you admit that you violated the terms of ILC?
Yes.
All right. What do you want to tell me about this?
I mean, I don't use cocaine. I did smoke marijuana, so I'm not sure if that's how it got in my system, but I'm currently pregnant, 10 weeks. And I'm just I've been attending my classes, doing everything that I've been supposed to be doing to be compliant with CPS as well as probation. When I didn't check in that day, I was supposed to come for a random drug screen. I ended up taking initiative and asking for a drug screen from Children's Services the next morning. Also, I took a drug screen that following evening that they said they would count towards missing my appointment.
All right. I am going to revoke your intervention in lieu of conviction, and I'm going to order that you serve 365 days in the county jail. I'm going to credit you with the 260. I just lost that number. What is it?
266.
I'm going to credit you with the 266 days that you have already done. And technically you're on community control while you're in the jail. So if you get caught with drugs, get into a fight, I could still send you to prison, but you just need to finish out your time and put all this behind you.
Okay.
Okay. Anything else?
Nope.
All right. I'm not going to impose a fine. I am going to impose the costs. Good luck to you, Ms. Gates.
Thank you. What type of termination would you like filed, Your Honor?
Let's do a neutral. State of Ohio versus Laura Yates. This is case number 23 CR 40344. Present before the court is Ms. Yates, right?
Sir.
And we have Mr. Harris in the prosecutor's office and Officer Ruff from probation. We're here today, Ms. Yates, because I received a report that alleges you have violated the terms of your supervision. You left this full circle and absconded in October of last year. You're positive for cocaine, it looks like in September of last year. And then when you were arrested, you were positive for meth at the jail. You have the right to be represented by a lawyer in the case. If you can't afford a lawyer, I'll appoint one for you. Do you want to be represented by a lawyer?
No, sir.
All right, Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated the terms of your probation?
I'm not.
Based upon your admission, I find you have violated the terms of your supervision. Mr. Harris, anything from the state?
Your Honor, my understanding is recommendation is local time and terminate. She has 324 days of jail time credit at this point.
Anything you want to tell me, Ms. Yates?
No, sir.
All right, doesn't make sense to continue to supervise you. I am going to Order that you serve 365 days in the county jail. I'm going to credit you the 324 days that you have already done. You're still on probation during the time that you're in the jail. So if you get caught with drugs or get in a fight, I could still send you to prison, but just finish out your time, put all this behind you. All right, good luck to you. Next is the case of the state of Ohio versus Christopher Griffin. Case numbers 25 CR 42381 and 25 CR 42803. Present before the court is Mr. Griffin, right? You're Mr. Griffin, right?
Yes, sir.
We have Mr. Harris from the prosecutor's office, Officer Ruff from probation. We're here today, Mr. Griffin, because I have received a report that alleges you have violated the terms of your supervision, that you were unsuccessfully terminated from the CCC program in January. Although I do have an email here from Officer Torak that says that may not have been entirely your fault.
What is it?
That you got kicked out of CCC.
I never got kicked out, sir. I got medically discharged.
Okay. Well, the plan is, in the case, Mr. Griffin, is to see if we can get you back into the program. I'm looking at the email from Officer Torak, and it doesn't look like we have a final word from CCC, whether they'll take him back or not, right, Officer Ruff?
It looks like in the additional information, he did put that he is still welcome to return back to CCC to complete the program, and that they had confirmed it with him as well as his Butler County officer.
I had I completed everything up until, I even got my early release for February 2nd, right? Well, I got sick. I remember, if you do recall, during my syphilis came back. I've got it now, and it's really come back strong. It's messed with my eyesight. My mother brought up the paperwork yesterday. And they told me they didn't have the medical staff there to treat me. I only had 25 days left to finish and I was going to go home. I've done everything I'm supposed to do. I ain't been in no trouble. I've done all my classes. I was a dorm rep there. I've done everything I was supposed to do, and I just got ill. And I need medical treatment bad. I mean,
what's Butler County going to do with your case, Mr. Griffin? Do you know?
They terminated my probation there.
All right.
And I'm supposed to when I was released from CCC, I'm supposed to do 60 days on house arrest. I mean, I need to get out and get my health. I don't want to die in here. I got a deadly infection.
So here's what I'm going to do, Mr. Griffin. I'm going to set this over for a final hearing probably in the early part of next week so that we can have some time to put a plan together. It really doesn't make sense to send you back to CCC for just, the last little bit that you have left.
There's no way that I can be on house arrest or something, get on house arrest and get my, because I'm sick, I'm very sick right now. I'm ill.
Yeah, I'm not against that necessarily, Mr. Griffin, but I don't have a good solid plan in place to do that today. So I'm going to set this for another hearing at the beginning of next week. And Officer Torak and I are going to get together. We're going to try to put a plan together where we can get you out of jail on EM and into some sort of outpatient as if you would have said.
That was my plan, to go back to Sunrise. I was going through Sunrise when I got locked up. I wanted to go back there. I wanted to go back to Sunrise, and even if it was going to put me on house arrest until my time was up there, I was going to do it. I just need to. I'm scared, and I'm not comfortable. I'm not comfortable right now. My health is real bad. As far as my addiction and my mental stability, you helped me out on that. You've done a lot by helping me out with that. But my physical health, it's bad, and I don't, like I said, I don't want to die here. I'm not gonna get out here and get in trouble. I'm gonna do what I got to do. I need to get out here and go to the hospital and see if they want to admit me or, because it's come back and I'm going blind. I've lost almost all my eyesight in jail when it hit me the first time. And I'm not trying to run from nothing. I don't want to mess up what I've already put in, Your Honor. You understand what I'm saying? I've been locked up almost 10 months. And I'm not trying to get no trouble or run or get back on drugs. I'm just worried about my health, and I was hoping maybe you could see that in me and trust me on that I can get out here and be on house arrest order and do that. I'm not going nowhere. I'm not going to violate everything I got to do. I'll do. I'll drop clean urines. I'm sick and I need to get out ASAP and get help, Your Honor.
All right, I'm going to reschedule this early part of next week, Mr. Griffin. I do find that there's probable cause to believe you violated the terms of your supervision. I'm going to hold you in jail until the next hearing, and Officer Torok and I are going to put a plan together, hopefully, to get you out safely and both medical treatment, drug and alcohol treatment.
Okay, I just hope I make it that far, because like I said, as soon as I go blind tomorrow, I could die tomorrow from it. It's deadly. They even sent a letter. My mom told me that it's a disease, and they were supposed to check me every 2 months and never did. CCC never checked. They checked me one time and they never told me nothing. Never checked me the whole time I was in the whole time I was in the county jail. They ain't checked me none. I've been checked one time in the last 10 months and they said it was denied or something. The blood test was denied. And I don't know what all it's done to cause, what kind of bad things to cause that. Now I can hardly breathe now. They say my muscles are deteriorating from my bones and I'm having heart problems and I can't breathe right and my hands are going numb. I'm scared.
Mr. Griffin, we're going to do everything that we can to get a plan set up to get you out of the jail and get you back into the community so you can get help with your problems.
Okay, I mean, that's fine. I just, I was hoping we come up with a plan today, man. I'm scared, Man, my mom spoke to my probation officer yesterday, and he said that he was going to speak to you and speak highly of it, you know what I mean, and that I needed to be out and get myself taken care of. I could die tomorrow. I could die today.
That's true of all of us, Mr. Griffin. It doesn't matter how long you talk today. I am not releasing you from jail today. But I'm very interested in putting a plan together for your safety and for everybody else's.
Okay.
And that's going to take a little bit of time. Hopefully not too much.
Okay, thank you.
All right. Next is the case of the State of Ohio versus Reedus McCoy. This is case number 25 CR 42676. Present before the court is Mr. McCoy, right?
Yes, Your Honor.
We have Mr. Harrison, the prosecutor's office, Officer Ruff from probation. We're here today, Mr. McCoy, because I've received a report that alleges you have violated the terms of your supervision, that you admitted to using meth on January 9th, didn't do your treatment. The recommendation is that and you've already been screened for the partial hospitalization program at DeCoach.
Yes, sir.
A recommendation from Officer Evans is that I release you from jail, back on probation, to the DeCoach program on electronically monitored supervision.
Yes, sir.
You have the right to be represented by a lawyer. If you can't afford one, I'll appoint a lawyer for you. Do you want to be represented by a lawyer?
No, Your Honor.
All right. Ms. Carrilco has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver. Do you admit or do you deny that you violated probation?
I admit.
Based upon your admission, I find you have violated the terms of your supervision. I'm going to continue you on probation. I'm going to modify the terms of your probation to order that you enter into and successfully complete the coach program, plus any follow-up treatment they require. You're going to be on electronically monitored supervision with a curfew for approximately 60 days. I'll see you at the next probation review, which will probably be in about 60 days.
All right. Thank you, Your Honor.
All right. State of Ohio versus Luke Goshorn. This is case number 25 CR 42693. Present before the court is Mr. Goshorn, right?
Yes, Your Honor.
We have Mr. Harris in the prosecutor's office, Officer Ruff and Ms. Wilkerson from probation. We are here today, Mr. Goshorn, because I received a report that you violated the terms of your supervision by refusing to participate in the housing provided to you by Cardinal Treatment. The recommendation is, if you admit to this violation or are found guilty, is that we have a bed lined up, hopefully at Beckett Springs, get you back on probation and over to Beckett Springs.
Yes, Your Honor.
You have the right to be represented by a lawyer in the case. If you can't afford one, I'll appoint one for you. Do you want to be represented by a lawyer?
No.
All right, Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. Mr. Harris, anything from the state?
No, Your Honor, other than he has 153 days of jail time credit.
I'm going to accept your waiver. Do you admit or do you deny that you violated probation?
Admit.
Based upon your admission, I find you have violated the terms of your community control. Anything you want to tell me about this?
I think my probation officer went over with you a little bit. But
She
yeah,
did.
just-
Usually Officer Martinez doesn't trust us and she comes down to do these preliminaries anyway, but she's not here today, but I did talk to her about it. We got a plan in place.
I'm gonna get lined up for Vegas Springs here.
All right, I am going to continue you on probation. I'm going to order that you enter into and successfully complete the Beckett Springs program, plus any other requirements that we have on the mental health docket.
Yes, sir.
Let's get this case back on track, Mr. Goshorn.
Yes, sir.
All right, that's all. Tiffany Newport. This is case number 25 CR 43030. Present before the court is Ms. Newport, right?
Yes, sir.
We have Mr. Harris in the prosecutor's office, Officer Ruff, Ms. Wilkerson from probation. We are here today, Ms. Newport, because I've received a report that alleges you violated the terms of your supervision in that you were unsuccessfully terminated from the Genesis program because of behavior issues. You have the right to be represented by a lawyer in the case. If you can't afford one, I will appoint a lawyer for you. Do you want to be represented by a lawyer? All right. Ms. Kuroko has a waiver that tells me in writing that you don't want to be represented by an attorney. I'm going to accept your waiver of counsel. Do you admit or do you deny that you violated the terms of your ILC?
I admit that I did not complete Genesis. There was an issue with another inmate that had left here with me and had went to Genesis, said that I was intimidating her and threatening her. I had got my own bedroom the night before and phased up that morning, and then I get arrested by my probation officer saying I'm being terminated. I was supposed to graduate in 2 weeks.
All right, Ms. Wilkerson, we have a plan, right?
Recovery defined.
Okay. Mr. Harris, anything from the state?
No, Your Honor, thank you.
Anything you want to tell me, Ms. Newport?
No, I'm just ready to get, I'm grateful that I went to Genesis. I have no bad things to say about them. I'm ready to just live a normal life, finally.
But we don't have an acceptance and a plan yet with recovery defined, do we, or do we?
We do, they've accepted her into their sober living.
Oh, okay. All right. I'm going to continue you on intervention in lieu of conviction, Ms. Newport. I'm going to modify the terms of your treatment plan to order that you enter into and successfully complete the recovery defined program. Let's reboot this thing, see if we can't get it right this time.
Yes, sir.
All
Thank
right.
you so
Anything
much.
else?
Thank you.
All right. That's all. Good luck to you. Is that everybody, right?
Court does call the case of the people versus Shondell Barrett. Pardon? Yeah.
Here.
All right, I'll need a cameraman.
Okay. Hi.
Oh, there she is. Hello. We're waiting for your attorney, and as soon as no, take your time. You are growing a full human being. So I will wait for you. All right, I called Miss Barrett's case.
Barrett, okay. Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Barrett. Ms. Barrett, did you already state your name?
No, I don't think so. Thank you.
Apologies, Your Honor. Ms. Barrett is here for sentencing. We did review the TSI and the recommendation. We do ask that you adopt it. This case arose out of a financial situation, as is stated in the PSI. Ms. Barrett takes care of her grandchildren as well as her son, who requires full-time care. So we just ask that the court take that into consideration while sentencing.
Barrett, is there something you want to tell the court before I impose sentence?
As far as the financial goes, I mean, to state it, I do have my son, he has special needs, but that's about it. I don't have anything else to say other than that.
All right. Sentence of the court, you're to pay $480 fines and costs. I'll order 93 days in jail suspended. When do you think you can get that paid, ma'am?
I'm not sure. I want to know if I can get like a payment plan for that. Because
Sure.
Okay.
How much do you think you can pay a month?
Maybe, oh my God, $400 some dollars. Probably like $50.
Pardon?
50. I get one payment a month.
$35 per month. Till
Okay.
paid in full.
Okay.
All right.
That sounds good.
We'll do it that way. All right. Thank you, ma'am.
Thank you.
Court calls case, People versus Leslie Brown.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Brown. Mr. Brown, state your name and turn on your camera. It looks like.
Oh, there he is. There you go.
State your name, Mr. Brown, please.
You have to unmute, Mr. Brown. There we go.
Yes. All right, yeah, there we go. Leslie Brown.
All right.
Your Honor, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we ask that you adopt the recommendation.
Mr. Brown, is there anything you want to tell the court before I impose sentence?
No, sir.
Sentence of the court, $480 fines and court costs, 93 days in jail, credit 7. The balance is suspended. When can you get that paid, sir?
I can have everything paid on the 11th of February. I get paid bi-weekly, so I can have everything cleared out by the 11th.
By then? Okay.
Yeah.
So I'll indicate you're to pay that by February 13th, that Friday, 2026. All right?
Thank you.
Thank you.
Thank you.
Okay, so the People versus Calvin Dooley.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Dooley, who is approaching. Mr. Dooley. Thank you. Your Honor, today is the date and time set for sentencing. We did review the recommendation. We do ask that you adopt it. For the most part, we are requesting the court to consider a reduced probationary term, perhaps a 6-month term. Mr. Dooley is before the court for sentencing on a first-time operating while intoxicated case. His last conviction was over 10 years ago. This offense date was almost 5 months ago. He's had no other convictions or other interactions with the criminal justice system since that conviction last 10 years ago. And then this offense date, he has been compliant on bond. I know there was a report with some late tests, but he has been on the sober link for 3 months, blowing 3 times a day. He's not tested positive for any alcohol or substances. In this case, he was very cooperative at the scene. He blew a .13. He did bring $500 to pay his fines and costs. However, there was an issue with a clerical error at the court. He is not working right now because the case was filed or coded incorrectly, that he pled to operating while intoxicated, not visibly impaired. He got a letter from Secretary of State stating that his license was suspended when it should not have been. So he hasn't been driving because of that, which has.
That was right after the plea that happened.
Right.
Yes, I think they had brought that to my attention. We don't enter it. I mean.
This court, right. And I tried to explain to Mr. Dooley, that it was a human error, but it never should have happened because his license was improperly suspended. And obviously getting around in Michigan with no license is very difficult.
Especially out here. I remember it being brought to my attention, but like I said, I don't enter it. Did they get it corrected?
Yes,
I know of. To me, I mean, I ain't get nothing in the mail, so I haven't been driving still because I'm trying to honor what you said. So
I spoke with Miss Wielding this week, and she was able to contact the clerk's office, and the clerk's office emailed yesterday or Monday that they resent the abstract to Secretary of State. So
can you run it? I don't know that they ran it.
I can run it. I don't know who is the abstract.
Well, right, but I don't care about that. I just want to know because just run it.
So yeah, he does construction. So obviously not being able to drive, not being able to get to work has impacted that. So he has brought the $500 to demonstrate to the court that he takes it seriously. He wants to do what he needs to do. But obviously that has impacted things over the last couple of months. And I didn't catch it. Mr. Dooley brought it to my attention. He got the letter, I think, early December, and really just was kind of like, I want to comply with what the court says, but did bring it to my attention this week. So I wanted to bring it to the court's attention too, that obviously that's impacted his life significantly.
Is there anything you want to say before I say?
no, man. I mean, no, sir. I was really conversation with her, but it was like,
oh, you gave me a promotion.
No, I'm sorry. Like that. Pretty much, I learned my lesson with this. Like, I'm not a drinker. I just decided to go out with a few friends. I barely go out, so I did something stupid, and I'm paying for it with money, and that's pretty much like anybody that know me. Money is my everything. So you're making me spend it all. I learned my lesson. I'm good on
it. I don't know what this means.
And I was just trying to make sure that my paperwork do say
Visibly impaired.
Visibly impaired instead of driving under the influence, because not y'all court, but I had a prior situation where I was double charged. Well, I ain't gonna say double charged, but they made two. I don't know how to say it. I had two of the same charges on one case, and I've been trying to get my felonies expunged, and that was one of the reasons why they kind of held me up, because they said they put 2 counts, and I only got charged with, convicted of 1, and they had 2 counts. I just want to make sure my paperwork right, so at the end of this, I can actually do what I was priorly doing beforehand, trying to get my everything back.
So I see it as suspended, but it looks like he's operating off a 625G permit.
They did send me something to say a restriction for 190 days.
Yeah.
And they extended it some more because of taking a plea to the DUI or whatever. So they extended it to November. It was supposed to be to June, but then they extended it to the 11th of November, 2026.
Yeah, well, and I believe once it's corrected to visibly impaired, the restricted period is shorter than the
right.
operating while intoxicated.
I'm just looking for it.
And I think, Mr. Dooley, while the court's reviewing that, they did say that they fixed the file, so at the clerks at the front, they can give you all the paperwork that says that it was visibly impaired
All
for the
right.
people behind the glass.
All right, right at the front, right? I paid them too, though, right? That's
Yep.
where I paid them.
Yep.
So. Row. Here it is.
There's one more thing, they still gonna do the 30.
Now,
While I'm waiting.
well, that's the third.
30 days.
So once. So if the court is the so 30 days, you'll have to comply with that. For the 30 days for the suspension. I think we have to wait until Secretary.
I mean, suspension is suspended.
How long were you expecting the restriction?
How long was I suspended?
No.
Oh,
Council.
So it's visibly impaired, there should be no suspension, just I believe it's 150 days restricted, is that right?
No, I think you're right. I'm just saying, yeah, it should be restricted, but I don't see anything so weird. Because as I'm looking at it right now, on both parts of this that I would look at it, it tells me that that he's suspended. But then he has a restricted license. So they may be the same thing, but your suspension, suspended followed by restricted license.
Right,
So it's restricted.
once the suspension lifts.
if I can help you, they sent
But
me.
why does he have, I guess I'm trying to figure out.
Because they sent me.
They've got him suspended from December 24th through June 21st, 2026. Then he's eligible for a restricted, basically a 1-month suspension on his license. So as it sits right now, as I'm looking at this, he's not eligible to drive. Right now.
Right.
Until not this Friday, but the next Friday.
That's why I was saying they suspended it for a month. And she told me I wasn't supposed to be suspended.
Right.
So I'm having been driving, my fiance is driving.
She's having a driving?
And she don't like
Is she yelling?
She don't like driving.
Huh?
She don't like driving.
She doesn't like driving?
We on 3 vehicles.
Like with everything, like everything's your fault anyway. Right? Isn't that right, man? See? So you have my permission that as you're driving around to yell at him. Okay? Anyway, anything else you want to say before I present?
One question about the sober link, because I know I'm supposed to go right on probation. So it got me saying that I was supposed to blow again for 30 more days on the sober link. So I'm paying for that plus probation.
Pardon?
That's what I'm saying. I gotta pay for the sober link. I already know that, right? So you extended it for 30 more days after being on probation. So I'm gonna be blowing on the breathalyzer with the link.
And unless you want to do 4 days.
No, I'm kind of good.
I mean, that's what it is. Your sober link's extended for that period of time, and I don't give the jail time on this. All right. Anything else?
No, sir.
The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of early intervention and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and monitor compliance with recommended treatment. So therefore, the sentence of the court, I am going to impose the 12 months probationary term. He's to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. You're to pay $500 today. When do you think you could pay the balance, sir?
When I can get a job.
Okay, well, that doesn't help me here. So what I'm going to do is pay $500 today. than a payment plan as arranged by probation. Do it that way. New use of alcohol, recreational marijuana, or any illegal substance, you'll be subject to random testing as requested by probation. You're to complete the alcohol highway safety education program. You're to provide proof of victim's impact panel attendance to probation. The sober link will continue for an additional 30 days in lieu of 4 days in jail. And sir, I'm just gonna remind you that you got some later missed tests. Just don't miss any of the tests because I don't want to impose the jail time, but I will. And then I'll order 93 days in jail. Credit 1, the balance suspended. Just briefly back to the, where would I don't see on here where there's a correction. Where there's a correction to the abstract.
Your Honor, I looked at it as well. I don't see that it's been done. It still shows an operating.
Yeah, it's still showing up as that charge, and if it were corrected,
It's less points.
well, it's less points, but it's also, it would, I'd see the correction, like he wouldn't currently be suspended.
Right. I just think it hasn't made its way. Carrie emailed me.
Who did?
Carrie, is it
Carrie?
Miss Carrie, or I don't know if Carrie's his first name, I apologize.
What date was that? Because
that was this week, so that's why I think, oh yeah, Mr. Jones on, Tuesday, so I don't know how long it would take.
Tuesday.
This week.
So yesterday.
Yeah, so he says that the charge is corrected in JAS and a corrected abstract was sent to Secretary of State. So I think that's why it
So
just hasn't.
JIS shows what he put.
Now, yes.
It does. All right. Okay. All right, thank you. If you have that email, just make sure that for your client's sake to hold on to that email in case something goes haywire. But I mean, after next Friday, I don't think there's going to be an issue.
Yeah.
For sure.
Yeah. But the points should be corrected and his criminal history should be corrected. So that's
right. And I can see something else on there. I don't have it right in front of me, but that's okay. The points might be important because I think he had something out of Monroe. Relatively recent, something that I saw, and you don't want to get to that threshold that all of a sudden, next thing you know, you're down there trying to figure out that they start doing something else because of that. So if we can also make sure, and then we'll get to PD's office, that why don't we look at just mark a calendar next Wednesday to run it and check it, and then we'll make sure that it's off, because that's going to be important, because once the suspension period ends, they're going to look at it there anyway, and that could cause some problems. So we'll double check on it. Okay.
Thank you.
Calls the case, People versus Sandra Leonard.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Leonard, who is present on Zoom. Ma'am, can you please state your name for the court?
Sandra Leonard.
Thank you.
Thank you, Your Honor. We have reviewed the pre-sentence investigation report and we have no material changes, and we would respectfully request the court adopt probation's recommendation.
Ma'am, anything you want to say before I impose sentence?
No, sir.
Sentence of the court, $500 fines and costs, $1,964.80 restitution to Costco payable through the court. When can you get that paid?
By tomorrow.
Okay. I'll indicate pay it by Friday, the 16th.
Yes, sir.
I'll order 365 days in jail, credit 2, the balance suspended. All right, thank you.
Thank you, sir.
Thank you, Your Honor. Thank you, Ms. Leonard.
Court calls the case, People versus Asandu, is it my Kaika?
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Lekaka. Mr. Lekaka, state your name for the record, please.
I don't have her.
And I did speak with my client this week. Provided him with the necessary information. I don't have an explanation for it. Unfortunately, I request of adjournment for the record to get him here.
Right, except that he didn't appear for his PSI either.
And Your Honor, he also was in contact with my office yesterday afternoon.
He what?
He was also in contact with my office yesterday afternoon, so he knew he had to appear today, given that I would ask for it.
Defense warrant will issue bond $7,500, 10%. That warrant will issue immediately. Court calls the case of the People versus Donnell Miller.
Assistant Public Defender Natalie Pate, with and on behalf of Ms. Miller. Ms. Miller, can you please state your name for the court?
Donnell Miller.
Thank you.
Thank you, Your Honor. Ms. Miller and I have had the opportunity and have reviewed the pre-sentence investigation report, and we do not have any material corrections. We would ask that the recommendation, we would respectfully request that the court adopt it.
Remember anything you want to tell the court before I impose sentence?
No, sir.
Sent to the court, 4 months prosecutor deferred sentence, $500 fines and costs, $120 probation oversight fees. When can that be paid?
I can do it today if they take credit card.
Yeah, you might want to shoot for tomorrow or later in the afternoon today. I'll just put that you'll pay it by this Friday, the 16th.
Okay.
No use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. No going to any Costco store in the state of Michigan. I'll set a review hearing May 13, 2026 at 9 a.m. I'll order 365 days in jail. That is suspended. Thank you.
Thank you, sir.
Thank you, Your Honor. Thank you, Ms.
Court
Miller.
calls case People versus Jaden Patrick.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Patrick, who is
Your name, sir?
Jaden Patrick.
Thank you, Your Honor. Today's the date and time set for sentencing. We have reviewed the pre-sentence investigation report, real corrections, and as to the recommendation, we were also able to review that and we respectfully request the court adopt it.
Anything you want to say, sir, before I impose sentence?
No, Your Honor.
All right. Place you on 9 months probation. You're to pay $555 fines and court costs, $270 probation oversight fees, $300 restitution to Sydney Wolf. We will apply the bond as to that. But not everything, we didn't have enough. Okay. So the bond will go toward the restitution. Then how are you going to pay the fines and costs?
I can pay probably half tomorrow, get half paid, and then I'll do the rest probably in like 2 weeks.
So how much can you pay tomorrow?
How much is it total? I think she told me 800. I could do like.
Well, we have the 300 for the bond for the restitution. So, yeah. So how much can you pay?
I'll pay like 400 tomorrow.
400 tomorrow. Okay, I'll give you 400 by Friday, and then you're gonna have the balance paid 2 weeks after that?
Yes.
Okay, and then the balance by January 30th. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. No contact with Sydney Wolf directly or indirectly. You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 36 served. The balance is suspended.
Thank you.
Thank you, sir.
Thank you.
Court calls the case of the people versus Anjanae Randolph.
Assistant Public Defender Natalie Tate with and on behalf of Ms. Randolph, who appears on Zoom. Ma'am, can you please state your name for the court?
Ajane Randolph.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity and did review the pre-sentence investigation report. I only have one brief kind of change. My client advises that she actually lives in Ann Arbor and she works in Ypsilanti, and I believe the report may have that the other way around. Other than that, we have no other changes and would request the court adopt the recommendation.
Ms. Randolph, anything you want to tell the court before I impose sentence?
No.
Sent to the court, you're to pay $480 fines and costs, $516 restitution to Walmart payable through the court. When are you going to get that paid, ma'am?
I have $200 I can pay today, and then I get paid bi-weekly. I can make payments bi-weekly if that's available. And I can.
So you have $200 today, realizing the restitution has to be paid in cash, right?
Yeah, she did tell me that. So.
Okay, so if you pay $200 today, how much are you going to pay every other week?
I really want to get it paid off within like the next 2-3 weeks. So maybe like.
Pardon?
I really want to get it paid off within the next within the next month, honestly. So
It went from 2 to 3 weeks to a month.
Because I have to think I get paid every 2 weeks, not every week. So.
Right. So can I? Let's see. That's about 900. Well, it's about almost $1,000.
Almost 1,000, yes.
So every other week, what are you going to pay?
Yeah, 300.
300. Gotcha. All right. So you're going to pay 200 by Friday. I'll just put by Friday, and then 300 every other week afterwards. All right. That'll work. And 93 days in jail suspended. All right. Thank you, ma'am.
Thank you. And do I just come into the courthouse and pay it? Or is
Yes,
there
come into the courthouse. We'll be more than happy to take your money.
Okay, I'm on my way.
No. All right.
Thank you.
You're welcome. Court calls the case, People versus Miles Rowe.
Assistant Public Defender Lauren Perry on behalf of Mr. Rowe. Mr. Rowe, state your name for the record, please.
Miles Rowe. All right, go ahead.
Your Honor, today is the date and time set for sentencing. I did review the probation recommendation with Mr. Rowe. We do ask that you adopt the bulk of the recommendation with the exception of the 5 days in jail. On behalf of Mr. Rowe, we are asking that the court either strike that recommendation or hold the 5 days in abeyance. Obviously, while Mr. Rowe is on probation, he will have the whole 93 days kind of hanging over his head if he were to violate his probation. He does understand that and is ready to complete this term. Regarding the 5 days, he did let me know a couple reasons why this would have a negative impact on his life circumstances right now. He is working a temporary job, or he's working a job where he's a temp. He's in his probationary period, basically. He's just a few weeks away from those 90 days where then he will be made a full-time employee. He doesn't have any time off or any sick or vacation days that he can take for the next couple of days. So he's very worried that he will lose his job if he were to be remanded. Additionally, he does have 2 children, a 16-year-old and a 4-year-old. He told me his 4-year-old will be with him full-time this weekend. The child's mother is going on vacation, so he is the primary caregiver for the next couple of days. So obviously does not want to be away from his child. He is also helps care for his family. His father just had back surgery. They own a farm up north, so he assists with that farm.
Down here too.
Two farms, okay.
Yeah.
So he assists with that farm, especially given his father's medical conditions, helping with run the farm and helping his father through this medical situation. His girlfriend is here as a support system. His family is very supportive of his sobriety. He even mentioned that his sister's going to school for drug counseling, and she's supportive of his sobriety. We've had multiple conversations over the last couple of weeks. He, I think, is very ready to be sober. He's talked to me multiple times about how this has basically changed his life. He appreciates the tether, keeping him accountable. He says he's willing to wear it for as long as the court wants because he appreciates the changes that being sober has made in his life. He did do as an assessment. The assessment says he's low risk for consumption because he also demonstrated to the assessor that he's ready to change his life conditions and is really on a good path. We also did talk lastly about the fines and costs. He believes he can post at least $400 today.
So anything you want to say before I impose sentence?
I mean, I could pay the whole thing in full today if I don't have to do the 5 days. If I have to do the 5 days.
Does this look like a negotiation to you?
No.
Go ahead. You can tell me anything else you want.
I mean, I'm just afraid of losing my job, so I wouldn't be able to pay.
Well, then you should have thought about that before you tampered with our device.
I didn't do a tamper with it, but I don't, as I did, so it is what it is. I don't know what else to say. I was just working.
Go ahead, sir. Anything else you want to tell me?
Other than the fact that being sober is about the best thing that I've had happen to me in about 10 years. So I appreciate it. And I take full responsibility for my action and hate that it happened. And I want to move forward and just move on with my life and take care of my family and not lose my house and keep everything going.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, driver's intervention class, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and monitor compliance of recommended treatment. Therefore, the sentence of the court, you're placed on probation for a 12-month period in time. You're to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, and $360 probation oversight fees. Pay $400 today. How are you going to pay the balance?
I can do a payment plan for whatever.
A payment plan is directed by probation. There's to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You are to complete outpatient treatment, including all recommended aftercare with status reports to probation. You are to provide proof of victims' impact panel attendance to probation. The scram tether will continue until proof of treatment is received by probation. So with reference to the jail time, and why I'm clearly indicating that this is not it's not a negotiation of fines and costs. You were 0.224, and there was a crash of the vehicle that very well could have been a crash that took somebody out.
I know.
So, well, you can know it, but I don't know that you appreciate it. You're not in a position to negotiate. Then when I put you on the scram tether, I all of a sudden get a notification of a tamper with it. And through the tamper, it still suggests that there was alcohol. And you're telling me you didn't do it, but
I was running a chainsaw with the fumed ethanol gas in it. I mean, that's just the only thing I can say. That's all I can say.
There's not a chainsaw in the world that's going to set that thing off.
I mean,
93 days in jail, credit 1 day served. Defendant will serve an additional 5 days in jail due to the bond violation, and then the balance will be suspended. Defendant's remand. Court calls the case People versus Dean Thrush.
Under Natalie Pate, looking on behalf of Mrs. Thrush, who is on Zoom. Sir, can you please turn your camera back on and then state your name for the court?
Let me see if it was on. Okay, here we go. Can you see
there
me
it is.
now?
Yes, we can see you.
Good
State your
afternoon, Your
name.
Honor. Dean
Good
Thrush.
afternoon, sir. Thank you.
Thank you, Your Honor. We have reviewed the pre-sentence report, Your Honor, and we do not have any changes or corrections, and we would respectfully request that the court adopt probation's recommendation. The only thing I would add is I believe Mr. staying with some friends of his right now, while he's trying to get back on his feet. I believe he will be asking for a payment plan as to the fine, Your Honor.
Mr. Thrush, anything you want to tell the court before I impose sentence, sir?
Yes, I am very remorseful for what I did for such a dumb idea to try to help somebody that was helping me. It was a stupid idea, and I'll never do that again.
Okay. Sentence of the court, $480 fines and cost. How much can you pay a month, sir?
About $50 a month.
How much?
About $50 a month.
All right, I'm gonna say $50 per month. And then when are we gonna start that? When can you get the first payment in?
But the first of the month.
Okay, so we'll start at February 1st.
Yep. Sounds
Okay.
good.
All right, that's what we'll do. So $480, $50 per month beginning February 1st, 2026. I'll order 93 days in jail that is suspended. All right, thank you. Good luck to you, sir.
Thank you. Have a great day.
You too.
Thank you. Thank you, Your Honor.
That's that block, and then I got show causes at 12. All right. Court standing in brief recess. Did they call back yet?
Not yet. It's coming through now.
You really one game before me. He's there for a drunk driving.
With the number of dependents, I will find that you qualify and appoint Attorney Darren Patterson. Do you have a pencil to take down Mr. Patterson's name and number?
Marty. Oh, I think, is there a way I can put it on here like a message and then screenshot? Yeah, okay, I have it. What's the number?
It's 316-322-7700. Darren Patterson.
Okay.
Call him as soon as court is over and tell him your contact information. And Jenna, when are we putting her on Darren Patterson's next available?
April 13th, Your Honor.
I'll need to be back here by Zoom again with Mr. Patterson, April 13th at 8 a.m. So
Okay.
make sure you call him and you give him that court date and contact information. It doesn't look like you've had your picture and prints taken. With that B misdemeanor, I'm gonna have to order that you do that. I'll set your bond at 1,000 OR. Unless you want to be heard on that, Mr. Regier.
No objection if that is the court's order, Your Honor.
All right, so Ms. Baker, you're going to get an invitation to a breakout room on your screen here shortly. Click on that. You'll go into a private breakout room with this officer in the blue uniform, and he's going to set up a time for you to get your picture and prints taken and to post that $1,000 OR bond. Any questions about
If
that?
I can't pay, if I can't
Don't have
pay
to
that,
put
will
the-
I have to?
You don't put that money up. I'm making it on your own recognizance, your own guarantee that you'll show up. And if you don't, you'll get a bench warrant for your arrest. You'll probably get a bond forfeiture, which means you'll have to pay out that 1,000 out of your own pocket. But if you show up in time,
Okay.
you don't have to pay up the money.
Okay.
All right. Any more
Thank you.
questions about that? You're welcome.
No, you have a great day. I appreciate it.
Thank you, and you too. All right, Jen, if you'll please put Court Security 1 and Miss Baker in a breakout room.
She should have had an invite. There we go.
All right, she is gone. I think that's everyone. Do you, Mr. Regier, Jenna, Court Security, anybody have anyone else?
Nothing further from the state, Your Honor.
I'm good, Your Honor. I'll just wait for them to get back.
Okay, thank you so much. This docket is adjourned. Was there someone else that had something? Deputy Caulfield, did you?
I just said no one here. at the
All right,
court's
great.
court.
All right, well, thank you all. This docket is adjourned.
Thank you, Judge.
This is what's Spanish. PA District Court's back in session. The Honorable Jay Simpson presiding.
Maybe seated. It's crazy. Court does call the case of the people versus Ryan Atkins.
Assistant Public Defender Natalie Page, Mr. Adkins. Looks like he's on Zoom. Sir, can you please unmute and state your name for the court? We are prompting.
Oh, that's not him. Ryan Atkins?
Can you hear me?
Yes. I need that camera.
I'm trying.
I think that might be him, but there's just a filter on his face.
You got a filter. You got a filter.
Yeah,
That's
I'm
it.
trying to turn it off. I don't understand any of this. The camera says it's there it goes. There we go.
There it is, normal.
Can you see me now?
All right. Yes, we can see you now. You're not
Sorry.
you're not some animal. All right.
Ryan
Where are we
Atkins.
at? Thank you.
Your Honor, this is a show cause, I believe, on the balance on the closed case. I believe the balance may be still $470.
Yes.
I did leave Mr. Atkins' voicemail, but we were unable to actually have a conversation to discuss this, so I would ask him to give,
Ryan, how you gonna get this paid off?
Can you give me 30 days? I should be able to have it paid off in 30 days.
You know I can give you 30 days because I've done it before, but
Right. Well, I mean, yeah. I should be able to have it paid off in 30. What
Can
is
you get
it
it paid
for?
off by? Can you get it paid off by the end of February?
Oh yeah, for sure.
All right, I'm gonna put in here defendant to pay balance by February 27th, 2026. I'll set a review to make sure payment, what's my date in March?
March 11th.
Set a review for March 11th, 2026, 9 a.m. If you got it all paid off, Ryan, I don't need to see you on that date.
Okay.
All right. Thank you.
I appreciate it. Thank you.
Yeah. Court calls case People versus Nicole Bird.
Good afternoon, this is the Public Defender Lauren Perry on behalf of Bird. Not sure if Ms. Bird is here, Your Honor. She doesn't have a phone. I did try to communicate with her via email, which was successful past previous hearings, but
Got about 13, almost 1,400 on.
yes, I think last time we were here, she was applying for disability. It was turned out to see the progress on that.
Bench warrant will issue for defendant's failure to appear. Bond is sitting amount of $15,000. I'll give a 10% privilege. Warrant will issue immediately. Court calls case of the People versus Lamar Hampton.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Hampton. And I didn't have success presenting his phone. I did email him. I don't believe I received a response. I don't have an explanation for the failure to appear today.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Calls case of the People versus Keith Malone.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Malone. Contact Mr. Malone. I did not receive any communication back.
So yes.
F 752
That's right. Yeah, that's right. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege on that. Warrant will issue immediately. Court calls case of the People versus Zane Martin.
Good afternoon. Mr. President, Martin.
Oh, I did that name wrong. She's gonna yell. Go ahead.
State your name, Ms. Martin.
John A. Martin.
That name. I knew it. Right after I said it, and I said she's gonna come on, she's gonna start yelling.
It happens every time.
Yeah, you don't have to yell it out. You don't have to just
I'm
put me on
sorry.
Front Street like that. Why you say it like that? All right. Martin, you owe about 1,400.
I
How are
know.
you gonna get this? How are we gonna get this paid, young lady?
I can have it paid off for a fact by the end of February.
You could have it all paid off?
Yes, the 1410, yes.
All right, I'm gonna. Defendant to pay balance 1410 by February 27th, 2026. I'll set a review hearing on this one for March 11th, 2026 at 9.
Okay.
All right.
Thank you so much.
Thank you.
Bye.
Bye-bye. Court calls the case, People versus Marcel Murray.
Defendant advocate for Mr. Murray, who is present on Zoom. So if you say good word.
You need to unmute, Mr. Murray.
Good afternoon, Your Honor.
Good afternoon, Mr. Murray. I don't know why this shouldn't be in. I thought.
So Alexis from collections sent this over today so that you would have it for the hearing.
Okay. I mean, if they're gonna do it on every case. Mr. Murray?
Yes, sir.
Thank you, Your Honor. I'm assuming, I believe Your Honor may have in your hands the ability to pay form.
I just have a financial statement.
Oh, financial statements. They did instruct my client, because we did discuss the balance. I believe it's $1,215. He did indicate to me he didn't have anything he could pay right now. However, he does understand he would have to make payments on this. He is starting school full-time on the 20th of this month, and ultimately is asking for an adjournment of the show cause and get situated and make some payments to this court, and then come back and possibly consider ask the court at that time for potential consideration of some of the fines and costs. I just have.
So when are you starting school?
Sir, I start school January 20th, I believe. So this upcoming Tuesday. I'm going to WC3. I'm down here in Detroit, but it's kind of rough, you know. I'm in and out of places. I'm at the shelter sometimes, and I'm couch surfing pretty much. And it's really
All
rough,
right.
but you know, I'm doing it. I'm trying to make everything happen.
Here's what I'm gonna do. I'm gonna adjourn it to March 11th, 2026, 9 a.m. All right. If you're gonna file the ability to pay form, get that filed with the court, and then I'll take a look at it.
Oh, I already have, sir.
I don't have that.
I had got a message from one of your I believe her name was Alexis Wing. She's a collections analyst. She said, I received the form you completed online for a payment plan. However, you were set for a show cause hearing at 14A. You must attend the hearing. I will forward the ability to pay form to the judge's coordinator, be placed in your file for the judge to make his determination on your ability to pay.
All right. I don't have it. So I don't know if it got to us.
That information that you have.
The financial statement, that's not the ability to pay for.
That document is all that Ms. Wing sent over. I can ask her if she has more information.
Well, now, you don't know what to send me then. This is the I thought there was a different form. But anyway, here's what I'm gonna do. I'm gonna still put this out to March 11th. All right, young man. And then, we'll take a look at the ability to pay. All right?
Yes, sir.
All right. Send to your attorney, your school stuff.
Okay.
So, because I'll take that into account also, that you're in school full-time trying to do something else with your life, all right?
I appreciate you. Thank you, sir.
Thank you.
Thank you very much, Mr. Murray. Thank you.
Court calls the case, People versus Ladante Knowles.
Ladante Knowles.
Oh, there he is, okay.
Shit.
All right.
Your Honor, this is also a cause, I believe there's still a balance. I did leave this Knowles voice, at least the number, but we were unable to have a conversation about the balance.
I have 1229.
It is balance, I have, Your Honor, yes.
Mr. Knowles, how are you gonna get this paid?
I can afford to pay, or what's y'all minimum payment every month? I can afford probably 100 a month now.
I can't hear you.
Can you hear me now?
Yeah, I can hear you.
Okay. What's the minimum payment? I can probably afford to pay 100 a month. I've been out of work.
All right, defendant to pay $100 per month. When are you gonna begin that?
I can begin that. I can begin paying next month.
Beginning February 1st?
Beginning February 1st, yes.
February 1st, 2026. I'll set a review. Give me a date in April. Set a review April 8th, 2026, 9 a.m. Make sure these payments are starting to come in. Thank you.
Okay, you're welcome.
Case People versus Theory Reynolds.
Good afternoon, this is the public defender.
No. Oh, there he is. State your name, sir.
Theory Reynolds.
All right. It's also a show cause.
Good morning, Your Honor.
Good morning. You owe $360 is what I have.
Mm-hmm.
You gonna get this? How are you gonna get this paid?
I'm working on employment right now, Your Honor. I just was just released the end of last year from doing like 120 days. And I was under the assumption that I was getting time credit, jail, time served for this charge. I guess I was mistaken.
All right, here, get yourself a job, start paying on this. We'll take a look at it in April. I'll adjourn it out April 8th, 2026, 9 a.m.
Okay, thank
But
you.
start paying on this, young man.
Yes, sir.
All right. Thank you. Court calls the case, People versus DeMarcus Washington.
Good afternoon, this is the public defender Lauren Perry on behalf of Mr. Washington. Your Honor,
State your name, sir.
Marcus Washington.
yeah, Mr. Washington is currently appearing from inpatient treatment. I don't know how long he will be in treatment, but
You're in inpatient treatment, sir?
Yes, sir. I'm in Sparrow Farm.
Got it. Do you have an anticipated completion date yet or no?
Yeah, February the 2nd.
Okay, so let's do this. I'm gonna adjourn it out to March 11th, 2026, 9 a.m. Both of these cases, okay?
Hey, Judge Simpson,
Get yourself out of treatment.
Can I ask you a quick question real quick?
Sure.
Like, I did my whole time on this case, and I just don't get why I gotta pay and do the time. I just feel like it's really like
No, sometimes you gotta do both.
You gotta do both sometimes?
Yeah. And particularly where the fines, I think in this, I didn't do the original sentencing on it. Yeah, sometimes that's what has to happen, especially if a judge doesn't give you time out of the gate. So yeah, you could end up owing money and doing time.
Okay. Hey, what's my total that I owe though? I forgot.
Your total?
Yeah.
Let's see. In the one case, this is on 1559, 425. And on the other case, I have 607. So you owe about a little over $1,000.
Okay. All right. Well, I'm gonna start paying on it when I get out of treatment. You know what I'm saying? Get a job, do some transitional
No,
housing.
I understand.
Yeah.
Here's I'll make a deal with you. I'll take something into consideration. You get out and keep yourself clean.
Okay.
All right. I'll work with you, but you gotta start doing the right thing. You hear me?
No, I hear you.
Okay. All right. This is the first step. How's the treatment going for you right now?
It's hard. I ain't gonna lie. It ain't nothing I've
No?
ever tried to do. It's different.
And it will be hard, but trust me on this. All right. You stick to it. Okay. And while it's hard and it's real hard right now, and it's going to be hard certain days, in the end, your life is going to be so much easier.
Yes, sir.
All right. You don't have to start asking me about do I have to pay and do time? You know, you just don't. That it all of a sudden isn't you.
Right.
You hear me?
Yeah, I hear you.
All right. We'll see you in March.
All right.
Good luck
Thank
to
you.
you, young man. All right. Keep it up.
Okay.
Court calls case People versus Douglas Wren.
Assistant Public Defender Natalie Pate with on behalf of Wren, who is approaching. Please state your name, sir.
Douglas Wren.
All right.
Thank you, Your Honor. Today's the date and time set for show cause. My records indicate that the balance is currently 650. I did speak briefly.
Right. Yeah.
I did speak briefly with Mr. Wren. He indicates to me that he is still at Dawn Farm. I'm unsure if is it inpatient or transitional housing at this time.
Inpatient.
Okay, you're still inpatient at Dawn Farm. Okay. What's it look like in terms of your completion date
The 20th.
of this month?
Yep.
Okay. And then are you gonna then go transitional or
Yes.
something like that? All right, let's do this then. Let me do the same thing I did with this last year. I'm gonna turn you out until March 11th, 2026, 9 a.m. And then we'll take a look at what I'm gonna want you to do with this. How's it going for you with the inpatient?
Great.
Is it?
Yeah.
How long you been in?
Over 120 days.
Inpatient.
Yep.
Okay.
Kid from the county jail to there.
To there?
Yeah.
Okay, and it seems to be working out for you, at least right now for you?
Yes, sir.
All right, fantastic. You've been in, you know what? How many more cases do you have out there?
I'm in County's drug court.
Are you?
Yeah.
You've been inpatient 120 some odd days.
Yes. Since August 3rd. September 3rd. since September 3rd.
Long as you been sober?
Almost 6 months.
I think that deserves some credit. Congratulations to you on that, because that, like that guy was saying, it's hard. It was hard, I bet. Real hard.
Yeah.
Okay, so what I'm gonna do for you, sir, is this. And I've seen you sitting here all morning, waiting for your case to be called, but you got here on time. I can't waive the state fees of $125, but I'm gonna waive everything else, and you're done with me. All right, all I want you to do is live your life and stay sober. You hear me?
Yes.
All right, take care.
Thank you.
You're welcome.
Thank you, Your Honor.
What'd you say?
I said you and me both.
Yeah. Court calls the case, People versus Reginald Moore. Hello, what's your name? Reginald Moore. Mr. Moore, you're here. I'm gonna show cause because you owe $644. How you gonna get that paid?
I could pay it not this check, not next week, but 2 weeks after next week. So the end of February. The end of February.
You can get it all paid?
Yeah, I got a job, so I paid them on not this check. I gotta pay something on this check. Through here,
Pardon?
actually. I gotta pay something for the court next week through here. Then I can pay the check after that.
Okay, so you think you can get this balance paid off by the end of February?
Yeah, I'm trying to get it out. I'm trying to get
I
out.
know you are, but you get
I paid you said 644?
644. So I'm gonna indicate defendant to pay balance by February 27th, 2026. I'll set a review hearing on this for March 11th, 2026 at 9 a.m. All right. And like I was saying to some of the others, if you got it all paid off, I don't need to see you.
Okay.
Okay?
All right.
Get it
Appreciate
done.
Appreciate it.
All right. Take care.
You too.
Have any more files? I want to do more.